Mr. Chairman, I appreciate the chance to say a few words as well, and I don't know that I can add to the kind words and accurate words that you said. He was an amazing person, amazing colleague, an amazing American, who we all know was truly committed to liberty for every single individual. And I know the whole Congress, the whole country is thinking of Mr. Lewis's family, and we all mourn his passing. With that, I yield back.
I am told that because of a technical difficulty, nothing I said went out, so I'll say it again. Before we begin the hearing, I want to take a moment to remember our dear colleague and beloved friend, John Lewis, who passed away last week. John was not a member of this committee, but his life's work in pursuit of justice and equality for all Americans continues to inspire and inform the work that we do in this committee. When we work to ensure that all men and women have the right to vote, we remember how John almost gave his life on the Edmund Pettus Bridge in the fight for voting rights. When we pass gun safety legislation, we remember that it was John Lewis who led the sit-in on the House floor to demand that we take action and protect lives. And now, in this moment of national anguish and moral reckoning over racial injustice and other forms of inequality, we remember a man whose entire life was dedicated to bringing about a more just and more inclusive America. John Lewis was truly the conscience of the country and the conscience of the Congress and of the entire country. My heart goes out to his family, his staff, his constituents, and all who knew him personally during this difficult time. May his blessing be a memory. We'll now proceed. Well, I would ask, these apparently didn't get heard either. I would like to remind members that we have established an email address and distribution list dedicated to circulating amendments, exhibits, motions, or other written materials that members might want to offer as part of our markup today. If you would like to submit materials, please send them to the email address that has been previously distributed to your offices, and we will circulate the materials to members and staff as quickly as we can. I would also remind all members that guidance from the Office of Attending Physicians states that face coverings are required for all meetings in an enclosed space, such as this committee hearing. Everybody attending this hearing is required to follow this guidance and to wear a mask. This is for the health and safety of all of us in this room, including our staff, and for the loved ones we will return to at the end of the day. I expect all members on both sides of the aisle to wear a mask except when you are speaking. Finally, I would ask all members, both those in person and those appearing remotely, to mute your microphones when you are not speaking. This will help prevent feedback and other technical issues. You may unmute yourself anytime you seek recognition. It is now my pleasure to welcome a new member of our committee. Oh, well, did Jim Jordan speak yet? Did Jim speak yet? Yeah, he did. Okay. It's now my pleasure to welcome a new member of our committee, Tom Tiffany. Congressman Tiffany was sworn in as a new member of the House just the other day, representing the 7th District of Wisconsin. We look forward to working with him, and we congratulate him on joining this Congress and this committee. At this time, I recognize the ranking member, Mr. Jordan, for any comments he may have.
Well, we're glad that Mr. Tiffany has joined us. Mr. Tom is a married, 3 children, graduate of the University of Wisconsin, something dear to my heart. Served distinguished record serving in the General Assembly and in the State Senate in the great state of Wisconsin, and so it's great to have someone from the Badger State and a great member now on our side and a member of this committee, and we welcome Mr. Tiffany to the committee.
We certainly join in welcoming Mr. Tiffany to the committee. As a result of several changes in membership that have occurred over the last few months, we will now consider new subcommittee assignments for the minority. I now recognize the ranking member, the gentleman from Ohio, Mr. Jordan, for the purpose of making a motion regarding subcommittee assignments.
Mr. Chairman, I move that due to changes in committee membership, including Mr. Ratcliffe's departure and the recent addition of Mr. Tiffany, I move to add Mr. Tiffany to the membership of the subcommittees on crime, terrorism, and homeland security, and on courts, intellectual property, and the internet, and to add Mr. Collins to the membership of the subcommittees on the Constitution, civil rights, and civil justice, and on courts, intellectual property, and the internet.
The gentleman has moved that the committee approve these new minority subcommittee assignments. All those in favor say aye. Aye. Those opposed, no. No. The ayes have it, and the subcommittee assignments are approved. Without objection, the motion to reconsider is laid upon the table. Pursuant to notice, I now call up H.R. 2678, the No President is Above the Law Act, for purposes of markup, and move that the committee report the bill favorably to the House. The clerk will report the bill.
H.R. 2678, to amend Title 18 United States Code to provide...
Without objection, the bill is considered as read and open for amendment at any point. I will begin by recognizing myself for an opening statement. The two bills we are considering today center around the same basic theme: presidential accountability. When the nation's founders wrote the Constitution, after having just fought a war against a tyrant, they stood fast to a key principle, that the executive must not be a king and must instead be accountable to Congress, to the people, and ultimately to the rule of law. H.R. 2678, the No President is Above the Law Act, reaffirms that important principle. This legislation, which I introduced along with Representatives Swalwell and Deutsch, would suspend the statute of limitations for any federal offense committed by a sitting president, whether it was committed before or during the president's term of office. This bill is necessary in order to close a dangerous loophole in the law created by Department of Justice policy, most recently embodied in a legal opinion by the Office of Legal Counsel, which holds that a president may not be criminally prosecuted during his or her term in office. Now, I certainly disagree with that opinion by the Department of Justice, but it will be executed by the Department of Justice, unfortunately. And under current law, and given their decision, there is, throughout the entire period that a president is presumed by some to be immune from prosecution, the statute of limitations continues to run on any criminal offenses that the president may have committed. Since most federal criminal offenses carry a 5-year statute of limitations, a president who is not prosecuted while in office for a crime he or she may have committed could end up evading justice altogether if the statute of limitations runs out before the term is over, particularly if they should be elected to a second term. Allowing complete immunity from criminal prosecution merely because of the office a person holds would make a mockery of the rule of law. Statutes of limitations are an important element of criminal law. As a general matter, they provide a necessary balance between protecting defendants from delay and allowing prosecutors adequate time to investigate and charge cases. They ensure that the possibility of a criminal prosecution does not hang over a defendant's head forever, and they encourage prosecutors to bring charges while evidence is fresh. But the law has also long recognized that certain limited exceptions to this general rule are necessary, such as when the commission of a crime has been concealed, or a defendant has fled or is unavailable. The case of a sitting president whose prosecution is barred under Justice Department policy, no matter how strong the evidence may be, fits comfortably among such exceptions. I would note that even if the OLC opinion is reversed, there may be many practical difficulties in bringing an indictment against the president who is still in office. It is necessary, therefore, to simply pause the statute of limitations so that the president, any president, can be held accountable for his or her actions, and to ensure that the presidency is not a get-out-of-jail-free card. I want to thank Mr. Swalwell and Mr. Deutsch for their work in helping to craft this legislation. The No President is Above the Law Act would ensure that every person, no matter his or her title or office, is held accountable under our laws. I urge all members to support this legislation, and I yield back the balance of my time. I now recognize the distinguished ranking member of the Judiciary Committee, the gentleman from Ohio, Mr. Jordan, for his opening statement.
Thank you, Mr. Chairman. Mr. Chairman, here you go again. Another day, another Democrat attack on President Trump. Democrats would like us to forget that the Mueller investigation, 19 lawyers, 40 agents, 50 interviews, 2,800 subpoenas, and $30 million found nothing. No collusion between Russia and the Trump campaign. Democrats would like us to forget Chairman Nadler's fishing expedition. Remember this? 81 letters sent to different people, different entities associated with President Trump, which also uncovered no wrongdoing. They'd like us to forget, actually, maybe they wish that we never even knew, that the officials from the Obama-Biden administration testified to the Intelligence Committee that there was no collusion at the time of the transition in 2017. And Democrats would certainly like us to forget the failed impeachment sham, the first partisan impeachment in history. The Democrats' impeachment was actually so unpopular that it actually made a Democrat member leave his party, leave that party, and become a Republican. But Democrats never let the facts get in the way of their false narrative. So here we are with this bill to toll the statute of limitations for federal crimes committed by a president during his time in office or even before office. I'm not sure what imaginary crimes this bill would address, and I'm not sure the Democrats know either. But they're convinced there's something somewhere if they just keep looking hard enough. I'll tell you what crimes you should be concerned about. What you should care about is the investigation that the Attorney General and U.S. Attorney Durham are pursuing. That's what really matters, not this partisan attack. 4 years ago, next week, the Obama-Biden administration started its weaponization of the Justice Department and the intelligence community to try to stop Donald Trump from becoming president. And the Obama-Biden administration used DNC-funded political gossip and Russian disinformation as a basis to spy on an American citizen associated with the Trump campaign. The Obama-Biden administration, including Vice President Joe Biden, unmasked the identity of General Michael Flynn 49 separate times. James Comey violated protocol to send FBI agents to interview Flynn at the White House with the goal of getting him to lie so that he could be fired or prosecuted. Again, it's not my words. These are the notes from Bill Priestap, the head of counterintelligence at the FBI. Then special counsel prosecutors pressured Flynn to plead guilty by threatening his family, threatening his son with prosecution as well. And on top of all this, the Obama-Biden administration and the Comey FBI knew by early 2017 that the collusion allegations were false, but they still put the country through 2+ years of turmoil. All these abuses right before our eyes, and yet our Democrat colleagues, people who claim they care about the civil liberties of American citizens, look the other way. Instead of righting these wrongs, they pursue imaginary ones, like this bill. This bill is yet another example of Chairman Nadler and the House Democrats' unhealthy obsession with going after the president. Instead of using this precious time to work with us on legislation that could actually help the American people, the Chairman is squandering critical committee business days to take political jabs at the president. Are we here to deal with the drastic rise in murders that we are seeing every day in the urban areas around our country? Friday night in Chicago, think about this, Friday night in Chicago, 49 police officers were hurt. Are we here to work together to enact real policing reform that keeps our community safe while also holding law enforcement accountable? Nope. Are we here to look at ways to prevent those in power from spying on their political opponents, like what happened in the Obama-Biden administration? Rather than focusing on significant bipartisan legislation for the American people, here we are once again choosing to prioritize these attacks on the president instead. House Democrats have shown they will take every opportunity to attack the president, regardless of the truth, regardless of the facts. This bill is nothing more than a legislative manifestation of that desire. The American people will see right through this stunt again. After nearly 4 years and countless wasted hours of partisan investigations, Chairman Nadler is yet refusing again to let go of the collusion delusion. I think we can do better than this, and we should be focusing on the things that matter to the American people. With that, Mr. Chairman, I yield back and certainly urge a no vote on the bill.
Without objection, all other opening statements will be included in the record. I now recognize myself for purposes of offering an amendment in the nature of a substitute. The clerk will report the amendment.
Amendment in the nature of a substitute to H.R. 2678, offered by Mr. Nadler.
Without objection, the amendment in the nature of a substitute will be considered as read and shall be considered as base text for purposes of amendment. I will now recognize myself to explain the amendment. This amendment in the nature of a substitute makes a minor change to the title of the bill, renaming it the No President is Above the Law Act of 2020. Otherwise, it does not change the substance of the bill in any way. I urge all members to support the amendment, and I yield back the balance of my time. I now recognize the ranking member, the gentleman from Ohio, Mr. Jordan, for any comments he may have on the amendment.
Mr. Chairman, I yield back.
Gentleman yields back. Are there any amendments to the amendment in the nature of a substitute?
Mr. Chairman.
Who seeks recognition?
Mr. Stubie.
Mr. Stubie.
The gentleman is recognized.
I have an amendment at the desk.
The clerk will report the amendment.
Mr. Chairman, I reserve a point of order.
Gentleman reserves a point of order.
Amendment to the amendment in the nature of a substitute to H.R. 2678, offered by Mr. Stubie of Florida.
The gentleman is recognized for 5 minutes. I'll state right now I have no objection to the amendment. We'll accept the amendment
I still have my 5 minutes.
if you want it.
Yes, sir. Thank you, Mr. Chairman and Ranking Member Jordan. I would like to offer an ANS to the No President is Above the Law Act sponsored by Chairman Nadler. How many times and in how many ways can my colleagues on the left try and attack President Trump without merit? Their intentions to do everything possible to take down the president were apparent the day Donald Trump was elected. They started with Russia, moved on to Ukraine, and when their impeachment efforts failed, they decided they would have to satisfy their collusion delusion by trying to create new opportunities to attack the president. When does this end? The Democrats continue these meritless attacks on the president and assert without evidence that President Trump has committed crimes. But time and time again, they still found no collusion, no obstruction, and absolutely no evidence of criminal activity. Their disdain for President Trump knows no bounds, and it showed with their sham impeachment, and it is showing again with this sham bill. No matter how many rules the Democrats want to break or change, it will never change the fact that President Trump has not broken any laws. This amendment would level the playing field by going further to include vice presidents. Former Vice President Biden would not be excluded from this, as it falls within the 5-year federal statute of limitation. From the very beginning, Democrats were intent on giving Joe Biden a pass and hold him to a far different standard than President Trump. They've excused bad behavior, brushed aside whatever happened with Hunter Biden and Burisma, and silenced any opposition or questions about his conduct. We have glossed over the fact that Hunter Biden joined the board of directors at Burisma in early 2014, despite having essentially zero experience in corporate government, and was receiving $83,000 a month. And the Democrats want us to forget that during this time, Hunter's father, the vice president, Biden, was in charge of diplomatic efforts with the Ukraine, and the founder of Burisma was being probed for money laundering by the United Kingdom. They want us to ignore all of this, despite that during the failed impeachment of President Trump, several witnesses spoke about this conflict of interest and testified that it was improper. This includes Fiona Hill, a senior director at the National Security Council, who testified that there appeared to be a conflict of interest with Hunter Biden serving on the board of Burisma. George Kent, Deputy Assistant Secretary of State, testified that he went so far as to raise these concerns directly with the Vice President's staff in early February 2015. And finally, Ambassador Yovanovitch testified that she was prepared by the State Department to answer questions concerning Hunter Biden and Burisma during her preparation for Senate confirmation. And yet, despite all of this, the Democrats are still pushing this bill to continue to attack President Trump for political purposes. We have wasted countless hours and countless taxpayer dollars on this witch hunt because my colleagues on the left will still not even accept the outcome of the 2016 election. Enough is enough, and it's time to hold Joe Biden and the Democrats to the same standard as President Trump. I yield back.
Mr. Chairman, I withdraw my
Gentleman
point
yields
of order.
back. For what purpose does the gentleman from Tennessee seek recognition? Oh, I'm sorry, Mrs. Cicilline.
Mr. Chairman, I withdraw my point of order.
The gentleman withdraws his point of order. For what purpose does the gentleman from Tennessee seek recognition?
To strike the land.
The gentleman is recognized.
Thank you, Mr. Chairman. I appreciate your bringing the bill, and I have responses from my colleagues on the Republican side. They haven't addressed the reason, which is that the Justice President not during time in office, based on the LOC, there is a brief for tolling the statute of limitations when he's not under any jeopardy. Statute of limitations run during a certain time when you can be charged with a crime, and then give you the freedom to go ahead with your life and say the government has to bring an action within that time. Will it bring it because of the Justice Department's opinion? And that's exactly what Mr. Mueller said in the Russia situation. It wasn't really Russia, it was the obstruction of justice. He didn't say that there was no obstruction of justice. He simply said he could not bring in action because of the policies of the Justice Department that you couldn't indict a president. He put it over to the that you have the ability to impeach him, but of course that's another issue because it's political, and we weren't able to succeed in the Senate on the Ukraine situation, nor anything on obstruction of justice did we pursue. But the fact is, if you cannot be indicted because of the Justice Department position, then the statute of limitations should be told, no matter who the president is, no matter what the allegations or thoughts of a crime or no crime being committed. That's just good public policy. So I joined with you in this particular bill. I think it's a long time coming. It's been an oversight. Of course, it hasn't been necessary until the Justice Department had their opinion that you can't indict a president during his term of office. So this is a good thing for both the Democratic president that may be in the future or the Republican president that presently exists. It's just play and common sense. And with that, I yield back the balance of my time and thank you for bringing.
The gentleman yields back. Who seeks recognition? For what purpose does the gentleman from Tennessee seek recognition? Does the gentlelady from Florida seek recognition? For what purpose does the gentlelady from Florida from Texas seek recognition?
We both are the epicenters of COVID-19, so I understand. We're both fighting, are we not, to save lives. Mr. Chairman, thank you so very much. I wish to do as was done at the beginning and just to acknowledge our late and beloved brother, the Honorable John Robert Lewis, and just briefly indicate that as we pay tribute on the floor of the House, how proud I was of all of the members of the United States Congress that came together to honor the boy from Troy, and most definitely one that stood in the gap for every crisis of inhumanity in his lifetime. And the one thing that we can say about John Robert Lewis, among many things, is that he was willing to pour into young people all of his spirit and knowledge and love. And so we thank him and honor him, and again we say rest in power. I have a single point to make on the legislation that's before us, accepting the manager's amendment, and that is the word oversight. My friends desire to utilize the existing president as the standard bearer, and that there is some malintent by members of the United States Congress. If we, who are an equal branch of government, fail to do our duty, which is that of oversight, then we have failed the American people. If I must use the present president, what I will say is that there are so many conspicuous ways that there is jeopardy to the pardon power and the presumption that the president may be above the law. As relates to the issue of above the law, after the DACA Supreme Court decision, there was a pronouncement by the White House that the president had now all powers. Since I adhere to the Constitution, I am baffled by what that means and troubled. That means this body, the Judiciary Committee, must provide the oversight to ensure that those powers do not abuse the rights of the American people. Additionally, we know that in the last 4 or 5 days, it was reported that the president asked the ambassador in Great Britain
since our inception in 1961, USAID has played a role in the national security apparatus, and we're proud to do so.
My time gentlelady from Texas will suspend. Someone is intruding on the committee by not having their mute button on, so please fix it. Thank you. The gentlelady from Texas will continue.
Thank you, Mr. Chairman. Asked a public servant of the State Department to assure that his golf course could have the British Open. We don't have any additional facts, or there's been no committee investigation, but oversight. And then finally, as it relates to the pardon legislation, which I know we'll be speaking about with amendments coming forward, I assume, there are many presidents the pardon power has been used all the time. The Judiciary Committee does not intend to restate law or to change the existing firm law, but it can clarify for the American people what it is intended. And in actuality, it is not intended, I believe, through constitutional law and cases for self-benefit, which would be the case if one pardoned one's self. So I believe these two initiatives are not an indictment on a single president, though the facts do prevail that allows us to have evidence that this is needed. Finally, Mr. Chairman, my friends have talked about policing. I think it is important to say that no member in this Democratic caucus and or in the Judiciary Committee that happens to be a Democrat has any angst or has ever argued against or stood against the lawful actions and the service of men and women wearing the uniform as law enforcement officers in the United States. And when I say that, there is an abidance in this country to law and order. There is also a respect for protests. As a member of the Homeland Security Committee, there has been no hearings or permission sought or understanding of individuals who are in a variety of responsibilities, U.S. Marshals, Secret Service, Customs and Border Protection, to be taking American citizens off the streets. And what I've always known is that the federal government, which is the umbrella of this nation, they've always engaged with local and state authorities, engaging except for the blatant violation of human rights and civil rights, that they've worked with state and local governments on keeping the peace. If a local government says we can handle it, we just have to wonder why there is a continuation of individuals unmarked, unnoted, and uncalled to be in various jurisdictions. I hope we'll have the opportunity to review that. I don't make a judgment, I make the judgment on those local authorities who have raised their voices. So, Mr. Chairman, I think that we are doing a simple task today that we are warranted in doing, and that is the oversight responsibilities of this committee. With that, Mr. Chairman, I yield back.
The gentlelady yields back. For what purpose does the gentleman from Florida seek recognition?
Mr. Chairman, move to strike the last word.
Mr. Gates, I said the gentleman from Florida.
Oh, sorry, Mr. Chairman. Sorry, Mr. Gates.
It's Mr. Chairman, at times it's like a meeting of the Florida delegation here in the House Judiciary Committee. I want to associate myself with the kind reflections of my fellow committee members regarding the life of John Lewis. We are all better Americans for having had the opportunity to know him and serve with him, and certainly our country is a more compassionate place as a consequence of his leadership during some of our nation's most trying times. I also want to support the amendment of my colleague from Florida, Mr. Stubie, because I think it really shows what we're doing here today. This isn't a hearing about the presidency. It is not a hearing about the rule of law, about maintaining anti-corruption endeavors. This is just an opportunity to continue to smear President Trump rather than working together to solve the serious challenges that are plaguing the nation. And the reason the amendment from Mr. Stubie really proves that point is that if we were really worried about corruption, if we were really worried about people exceeding the scope of their authority or power in a criminal way, then we would have that same concern for both the presidency and the vice presidency. I suspect in the Democrat debate on this subject, we won't be hearing why the presidency is so fundamentally different than the vice presidency, why we would tolerate corruption or illegal or improper behavior to a different extent in the vice presidency than with the presidency. No, this is just the death rattle of impeachment. The ghost of Christmas past, the ghost of investigations past, because the president was proven not to have engaged in any criminal collusion with Russia. There was no basis to charge the president with any obstruction of justice. And so here we sit, as cities in America succumb to violence, as our fellow Americans wonder when they call the police, will they be there to show up? Will the police feel confident enough to engage in the type of proactive policing that even Rahm Emanuel, the former Democrat mayor of Chicago, said was essential to public safety. It would be my hope that we would talk about some of the ideas that Republicans and Democrats have put forward to improve policing, to create more safety in our communities, and certainly to support a federal response when federal assets are under siege. Many of us have received briefings from the acting Secretary of the Department of Homeland Security, Chad Wolf, recently, who said that if the department were to pull back, if we weren't to secure these federal buildings, that they would be engulfed in flames and in violence. Our fellow Americans who work there, who go there expecting at times the provision of government service, wouldn't feel safe doing so. They wouldn't be safe doing so. And so it's certainly my hope that as the committee progresses in its work, we can sort of get over ourselves when it comes to the failed impeachment of President Trump, and we can move forward with the challenges that are facing the country. Again, Congressman Stubie's amendment points out the hypocrisy of the legislation and the, I think, misfocus of the hearing and of the day. I yield back.
The gentleman yields back. For what purpose does the gentleman from Florida seek recognition?
Strike last word.
Gentleman is recognized.
Thank you, Mr. Chairman. I support H.R. 2678, the No President is Above the Law Act, and I thank you, Mr. Chairman, and Mr. Swalwell for joining me in introducing this bill to ensure that the highest office in our government is accountable to the people and to the justice system. The criminal prosecution of a sitting president introduces a lot of tough issues. There's no doubt about that. The Office of Legal Counsel commented on these issues, and there's disagreement about foundational issues of separation of powers, and we saw those issues play out in the Mueller report 1 year ago. But we don't have to get into those thorny problems to know that this is a good bill. It's a good bill because it strikes to the root of the problem of accountability. Because getting elected to the presidency isn't supposed to be a get-out-of-jail-free card. And you certainly aren't supposed to be able to use the power of the highest office in the land to corrupt the administration of justice. We've fought a lot of battles in this committee over the actions of the current occupant of the White House. And I know my colleagues on the other side of the aisle don't see his conduct the same way that I do. But it seems to me that we've lost our way if we think that the highest elected office in this country is immune from prosecution if they can just run out the clock in the White House. Aren't we supposed to raise the bar for our elected officials? If public service is a public trust, then serving as president shouldn't close the door on accountability. And that's what the current system sets up. The president of the United States shouldn't be able to run out the clock on the statute of limitations by hiding under the Resolute desk. The president shouldn't be able to escape prosecution by fleeing to the White House bunker, and the Electoral College is no substitute for a jury of your peers. I urge my colleagues to support this bill to ensure that no president is above the law. I yield back.
The gentleman yields back. For what purpose does the gentlelady from Pennsylvania seek recognition?
I move to strike the last word.
Gentlelady is recognized.
Our country's long been a beacon of freedom to the world because we've honored both the spirit and the rule of law. And this is largely because our leaders have honored traditions and guardrails on our democracy that prize honor, duty, love of country, service to the public over self-interest. When those guardrails are no longer working, it's Congress's job to enact new guardrails or enact guardrails into law that were previously only tradition. There are certainly debates about the power to charge a sitting president, and we know that the Office of Legal Counsel has written memos saying that you cannot charge a sitting president, which brings us to the situation of what if a president, as Mr. Deutsch so eloquently put it, can hide under the Resolute desk to run out the clock. That's unacceptable. I disagree that the president cannot be charged. I disagree that he cannot be impeached for the conduct that has been disclosed thus far, and in fact, he was impeached. But I think this statute that we're considering today to toll the statute of limitations is a necessary corrective that should be a caution to executives going forward. And I yield back.
The gentlelady yields back. For what purpose does the gentleman from Florida seek recognition? The gentlelady from Florida, I'm sorry. Wait, yeah. Georgia. For what purpose is For what purpose does gentlelady from Georgia seek recognition?
Thank you, Chairman Natler and Chairman Schiff, for these common sense pieces of legislation. Also, thank you to Rep. Raskin for his amendment. Similarly, the Abuse of Pardon Prevention Act would add transparency and accountability to the pardon process. Pardons were never supposed to be a matter of political force or self-interest. In Federalist 74, Alexander Hamilton wrote that the pardon power was intended to address instances of unfortunate guilt. In other words, to address situations where the application of the law resulted in injustice. Presidents should adhere to this standard when exercising their power to pardon. This legislation will help ensure that they do that thing by requiring additional disclosures when there is a reason to suspect the pardon power may be being abused. It also requires disclosures when the pardon relates to a crime that harms the role of Congress and our duty to serve the people. These are modest reforms that bring much needed sunlight to the pardon process in a narrow set of circumstances. The No President is Above the Law Act does exactly what it says. It ensures that a president cannot escape unaccountability simply because he or she runs out of time on the clock while in office. Anyone who occupies the office of the president should be held to a high standard of conduct. At a minimum, he or she should have to follow our nation's laws the same as every American. This is purely common sense. The No President is Above the Law Act simply makes sure that every president is held accountable for his or her actions, both in and out of office. And I am pleased to stand with my colleagues in supporting these bills because I believe that transparency and accountability are critical values of democracy. They're critical values as leaders of this great nation. And our framers rejected monarchy. And today we strengthen their democratic vision by ensuring that no one, no president, no members of Congress, no leadership in this country are above the law. And I yield back the balance of my time.
The gentlelady yields back. For what purpose does the gentleman from Florida seek recognition? From Rhode Island seek recognition.
Mr. Chairman, I move to strike the last word.
Gentleman is recognized.
Mr. Chairman, thank you for holding this markup to ensure that no president is above the law. Not just the current president, but any president, Republican or Democrat. After walking out of Independence Hall after the Constitutional Convention in 1787, a woman asked Benjamin Franklin, "What have we got, a republic or a monarchy?" To which Franklin replied, "A republic, if you can keep it." While it's true that the Constitution gives presidents authorities to grant pardons to excuse or forgive a federal crime, such authority is not without limits. Since the framers ratified the Constitution in 1788, the President of the United States has had a duty to serve the interests of the American people. Our framers gave us a republic free from kings. The Constitution makes clear that the enormous powers of the presidency should not be used to advance a president's personal, political, or financial interests. Yet 31 of the 36 pardons or commutations issued by President Trump thus far have been guided by clear political agenda, connections, or fame. Never before have we seen the pardon power abused in such a flagrant way. The most egregious example is President Trump's recent commutation of his longtime friend Roger Stone, who was convicted of witness tampering, obstruction of justice, and 5 counts of lying to Congress to cover up the president's own wrongdoing. Such brazen cronyism and corruption are at odds with our Constitution and with our core legal principles that no one is above the law, not even the president. H.R. 7694, the Abuse of Pardon Prevention Act, reins in the abuses of the pardon power by imposing transparency and disclosure obligations when a president seeks to use that power for self-serving purposes or to undermine or otherwise obstruct Congress. Once again, faced with an unprecedented abuse of power by the president, we must not allow it to go unchecked. This is a proper role for Congress. As one colleague explained in describing the role of Congress, and I quote, "The role of Congress is part of a check and balance scheme. The power to pardon comes from the Constitution. It's important that Congress, even though we can't change the outcome, create a historical record to make sure that if it is an abuse of power, that it not happen again. And our role in the check and balance scheme is to review the conduct of the most powerful man in the country, regardless of party," end quote. And you know who said that? Then Representative Lindsey Graham. So failing to act would undermine our national security, our collective sense of justice, and the trust of the American people. H.R. 7694 reaffirms that under certain circumstances, offering or granting a pardon or commutation may serve as a basis for finding criminal culpability. To further ensure that a president can be held accountable for his or her crimes, H.R. 2678, the No President is Above the Law Act, makes clear that the office of the presidency cannot be used as a shield for violations of criminal law. It suspends the statute of limitations for any federal offense committed by a sitting president of any party, regardless of whether it was committed before or during the president's term in office. This isn't about President Trump. This is about safeguarding the rule of law in this country and making sure it applies to all presidents. In doing so, it guarantees that a president can be held accountable for criminal conduct, just like every other American. The No President is Above the Law Act and the Abuse of the Pardon Prevention Act are not about politics. The requirements of both of these bills would apply to any president, regardless of party affiliation. H.R. 2678 and H.R. 7694 make explicit, long-standing interpretations of our Constitution. Each member of this committee, each member of Congress took an oath and swore that we would protect and defend the Constitution of the United States against all enemies, foreign and domestic. That's why we're here today. I urge my colleagues to do what is right, vote for both of these bills, reaffirm what our Constitution already recognizes as true and which is a founding ideal of this country, that no person, not even the President of the United States, of whatever political party, is above the law. And with that, Mr. Chairman, I yield back.
The gentleman yields back. For what purpose does the gentleman from Arizona seek recognition?
Move to strike the last word.
Gentleman is recognized.
Thank you, Mr. Chairman. I support the Stubie amendment, and I think Mr. Gates' comments are right on the money. It's important to show some light on here because this is not anything more than an attack on President Trump, and that's really what this is about, regardless of the protestations of my colleagues and this very interesting notion of conflating the commutation bill that we're going to take up next with the tolling of the statute bill that we're discussing now when actually we're supposed to be discussing the Stubie amendment. But I just have got to tell you that one of the problems with this is holding the criminal prosecution over the head of a sitting president will, as we have seen, provide a cudgel to political opponents. And that's what we've seen since President Trump, before he was even elected. The constitutional remedy is impeachment. And once impeached, then you move forward with whatever criminal charge remains available. Well, but I got to talk to you just briefly because I'm kind of, I was going to save this for the next bill, but since so many of you have focused on the clemency, a reduction of sentence of Roger Stone, and I just thought I heard somebody say that we've never seen such blatantly political use of that authority before. And I'm thinking, well, Bill Clinton pardoned his own brother for a cocaine distribution felony. When Hillary Clinton was being probed, or I should say investigated, for the Whitewater scandal, suddenly a key witness received a pardon. Ken Starr's investigation produced 3 individuals who were prosecuted and convicted. They have received pardons. Mark Rich, big donor to President Clinton, received a pardon. So did his HUD secretary and CIA director. 8 people in an investigation of the Agricultural Department received pardons. And there's a whole list of others. I won't get there. President Obama pardoned Oscar Lopez Rivera, the leader of the fallen terrorist group. He commuted the sentence of a U.S. soldier who leaked top-secret information to WikiLeaks. The outrageous claims that we're here today under the guise of not being political just doesn't stand. I'll have more examples of previous regimes who've used the commutation and pardon power. I think this indicates quite clearly that this is being drawn. This is being drawn for political purposes. This attack is meant to be an attack on President Trump. Nothing more, nothing less. I just wish there was not that doublespeak that I hear. With that, I yield back.
Gentleman yields back. For what purpose does the gentlelady from Pennsylvania seek recognition? The gentlelady is recognized, and I would ask if the gentlelady would yield to the chair for a moment.
Absolutely.
I thank the gentlelady. I would simply point out that the bill that we are considering does not mention President Trump, does not mention anybody. All it says is that a statute of limitations shall be told during the tenure of any president. Everything we have heard is can only be because of the consciousness of guilt of the president by the Republicans. Otherwise, they wouldn't be talking about it. The bill doesn't mention the president. The bill doesn't mention anything. All it says is, as a general matter of law, statutes of limitations should be told on any president because that makes the law more fair. And what do we hear? The president hasn't done this, which he clearly has. The president hasn't done that, which he clearly has. What a guilty conscience. What complete admissions by the Republicans that this president has committed major crimes and should have been impeached, but for the cravenness of the Republicans in the Senate. But we're not talking about any of that. They're the ones bringing it up. All our bill says is the statute of limitations should be told for a president, period. I yield back.
Thank you, Mr. Chairman. I could not have said that better. I rise in support of the bill, Mr. Chairman, but I want to remind people that we are not operating here in this body in a vacuum. I am mindful of the gaping hole in our body as a result of the death of Representative John Robert Lewis. I am mindful that these dark days are met by very dark statistics. COVID-19 deaths and infections on the rise. Unemployment, another 1 million people. American cities being rioted on by its own government in unmarked cars with unmarked personnel. Russia's use of bounties on our own service members go unanswered by this president. Our relationships around the world in tatters, an unhinged president and presidency, corruption and cronyism a daily event, the rule of law in tatters, thanks to a Justice Department that is just a political arm of the president. But I'm mindful of this bill. As the chairman described, this bill suspends the statute of limitations for any federal crime committed by a sitting president, both during his or her tenure or before they assumed office. Academics and legal commentators sometimes debate whether a president can face criminal indictment during his or her tenure. What is beyond debate is the fact that every president is accountable to the laws of our country. With this bill, we are reaffirming the long-standing principle of American democracy that no one, irrespective of the power they hold, is above the law. The presidency of Donald Trump has challenged long-standing norms that kept the machinery of our government running smoothly. But this bill is not about him. It's about any president. And with the Stubie Amendment, it's about any vice president. Never before have we had a president and an attorney general willing to corrupt the powers of their office to evade the administration of justice. This bill is a reminder to them and to any future maladministrators that the powers of the presidency do not protect you from facing the consequences of your actions. You will be held to account, even if it must wait until your tenure expires. No one is above the law, and I yield back.
The gentlelady yields back.
Mr. McClintock, California.
For what purpose does the gentleman from California seek recognition? Gentleman's recognized.
It's true this bill doesn't mention President Trump, but it's also true Mr. Stubie's amendment doesn't mention Vice President Biden, but we all know what we're talking about. I support Mr. Stubie's amendment not because I agree with it, but because of the old maxim that what's good for the goose is good for the gander. I think Mr. Stubie's amendment makes the hypocrisy of the committee's Democrats crystal clear to everyone, and for that reason I intend to support the amendment. But it is bad policy in either case. Criminalizing policy disagreements is a very dangerous path to take. We have seen political prosecutions in recent years in a brazen attempt to influence elections and to undermine the duly elected president in discharging his constitutional duties. I think it's pretty well established the president can be charged for state offenses while holding that office, and he can be removed from that office and then prosecuted for federal crimes. In fact, that's exactly what the Democrats tried to do last year, and they failed. And the reason they failed is because they could not identify a single law that they alleged the president had broken in their articles of impeachment. Instead, they made up crimes that simply do not exist in the law. I get it. They don't like his politics. That's fine. That's a political matter to be taken up in a political process. But it is not a criminal matter. And if we allow it to become one, we have taken a giant leap toward fundamentally transforming our government from a constitutional republic into a banana republic. I yield back.
The gentleman yields back. For what purpose does the gentlelady from Florida seek recognition?
Mr. Chairman, I'd like to strike the last word.
Gentlelady is recognized.
Thank you, Mr. Chairman. Law and order. Let's remember the main substance of this bill, and that is to ensure that any president is held accountable, Republican, Democrat, man, woman, for crimes committed just like any other American would. We see President Trump tweet law and order numerous times, so I don't understand the resistance from my colleagues across the aisle on ensuring that no president is above the law. We should not allow any president to use the office of the presidency to hide and avoid legal consequences. And yes, Mr. Stubie, I am going to support your amendment. Vice presidents should also never be allowed to be above the law. It shouldn't be political. This is a moment in our history when we need to stand together, regardless of party, to ensure that now and in the future, we don't allow any president or vice president to go unchecked. It's a dangerous track that we're going on. And I assure you, I won't take personally the reference to Banana Republic, but I was born in South America. I know what it looks like when a man holds on to power and believes that they're above the law. We cannot allow that to happen in the United States of America. That is why law and order, yes, that we should be guided by the law here in the United States. That's why I encourage all my colleagues in this committee to stand united and pass HR 2678 so that we make sure that no one in this country is above the law. I yield back.
The gentlelady yields back. The question occurs on the amendment. Those in favor say aye. Aye. Opposed, no. No. The opinion of the chair, the ayes have it. The amendment is agreed to. Are there any further amendments to the amendment in the nature of a substitute? For what purpose does the gentleman seek recognition?
I have an amendment at the desk.
Mr. Chairman, I reserve the right to object.
The clerk will report the amendment. The reservation of the point of order of the right to object is heard. Clerk will report the amendment.
Amendment to the amendment in the nature of a substitute to HR 2678, offered by Mr. Biggs. Page 2, after line 3, insert the following.
Without objection, the amendment is considered as read. The gentleman is recognized.
Thank you, Mr. Chairman. This amendment provides for a statute of limitations of 10 years for an offense under Section 109 of the Foreign Intelligence Surveillance Act of 1978 involving
Excuse me, the gentleman will speak up so we can understand what he's saying.
Thank you, Mr. Chairman. This amendment would provide for a statute of limitations of 10 years for an offense under Section 109 of the Foreign Intelligence Surveillance Act of 1978 involving electronic surveillance of a political opponent. Much to the protestations that this bill does not apply and is not designed to attack President Trump notwithstanding, it is. But we see what has happened here. Using our nation's law enforcement intelligence gathering capabilities and authorities against a political opponent severely undermines our republic. Doing it to prop up an absurdly ludicrous conspiracy theory is even worse. In the words of the Attorney General, it is clear that the FBI launched an intrusive investigation of a U.S. presidential campaign on the thinnest of suspicions that were insufficient to justify the steps taken. We know that surveillance started during the Obama administration and went on through the duration of the campaign and even into President Trump's administration. In order to obtain and maintain FISA on members of the Trump campaign, FBI officials deceived and manipulated the FISA court in multiple ways. The FBI omitted crucial exculpatory information from their applications, and even worse, they buried information calling on to question reliability and veracity of their principal source. These investigations were led by people who had a deep animus against President Trump. People who were committed to stopping President Trump from becoming the president. On August 8, 2016, FBI Attorney Lisa Page texted to FBI agent Peter Strzok, "Trump's not ever going to become president, right? Right?" And Strzok replies, "No, he's not. We'll stop it." 2 days earlier, Lisa Page texted Peter Strzok. She said, "And maybe you're meant to stay where you are because you're meant to protect the country from that menace." Later, Strzok texts Page, "I want to believe the path you threw out for consideration in Andy McCabe's office, that there's no way he gets elected, but I'm afraid. We can't take that risk. It's like an insurance policy in the unlikely event you die before you're 40. These individuals sworn to uphold the law were tearing apart the fabric of our republic from the inside. A false narrative concerning our president and Russian collusion was concocted in the Hoover building. At the same time that they were denying no collusion privately, they were asserting collusion publicly. Then those same people used our laws to spy on Americans. That is a threat to our country, the fabric of this republic. Unfortunately for them, President Trump was elected and their scheme was exposed. Imagine if Secretary Clinton had been elected instead. We might not know to this day the treachery that took place. That is why we need to extend the statute of limitations for those that would illegally spy on Americans. Currently, that statute of limitations is 5 years. If you would hold that and expand that statute of limitations for presidents and vice presidents, you should do that for those who would be abusing our intelligence apparatus to spy for political purposes. This is not a Republican or Democrat amendment. This amendment protects all parties from being spied on by political operatives and opponents. With that, Mr. Chairman, I urge the adoption of my amendment, and I yield back.
The gentleman yields back. Does the gentlelady insist on her point of order?
Mr. Chairman, I insist on my point of order. This bill addresses a subject, or this amendment addresses a subject matter different from the underlying bill. I insist on my point of order.
The point of order is well taken. Clause 7 of House Rule 16 prohibits amendments that are on a different subject matter than the proposal that is under consideration.
Mr. Chairman,
the subject of the bill that we are currently considering is the criminal statute of limitations. The gentleman's amendment proposes to amend a different statute, namely FISA, which is a subject that is different from what we are considering in this bill. The amendment is therefore not germane and violates Clause 7 of Rule 16. The amendment is not, the point of order is well taken.
Mr. Chairman, I appeal the ruling of the chair.
The gentleman, The gentleman appeals the ruling of the chair.
I move the table, Mr. Chairman.
The gentlelady moves to table the appeal of the ruling of the chair. The ruling of the chair is tabled.
Roll
You
call
can't
vote.
just table it without a vote?
All right. Vote will occur. The clerk will call the roll on the motion to table.
Mr. Nadler?
Aye.
Mr. Nadler votes aye. Ms. Lofgren?
Aye.
Ms. Lofgren votes aye. Ms. Jackson Lee?
Aye.
Ms. Jackson Lee votes aye. Mr. Cohen?
Mr. Cohen votes aye.
Mr. Cohen votes aye. Mr. Cohen, you need to turn on your camera. Mr. Johnson of Georgia?
Aye.
Mr. Johnson of
votes
Georgia
aye.
votes aye. Mr. Deutsch?
Aye.
Mr. Deutsch votes aye. Ms. Bass? Ms. Bass votes aye. Mr. Richmond? Mr. Richmond votes aye. Mr. Jeffries? Mr. Jeffries votes aye. Mr. Cicilline? Mr. Cicilline votes aye. Mr. Swalwell? Mr. Liu?
Aye.
Mr. Liu votes aye. Mr. Raskin?
Aye.
Mr. Raskin votes aye. Ms. Jayapal? Ms. Jayapal votes aye. Ms. Demings? Mr. Correa?
Aye.
Mr. Correa votes aye. Ms. Scanlon?
Aye.
Ms. Scanlon votes aye. Ms. Garcia? Ms. Garcia votes aye. Mr. Neguse? Mr. Neguse votes aye. Ms. McBath? Ms. McBath votes aye. Mr. Stanton? Mr. Stanton votes aye. Ms. Dean? Ms. Dean votes aye. Ms. Mucarsel-Powell? Ms. Mucarsel-Powell votes aye. Ms. Escobar? Ms. Escobar votes aye. Mr. Jordan?
No.
Mr. Jordan votes no. Mr. Sensenbrenner? Mr. Shabbat? Mr. Shabbat votes no. Mr. Gomert? Mr. Collins? Mr. Collins votes no. Mr. Buck?
No.
Mr. Buck votes no. Ms. Roby? Mr. Gates? Mr. Gates votes no. Mr. Johnson of Louisiana? Mr. Johnson of Louisiana votes no. Mr. Biggs?
No.
Mr. Biggs votes no. Mr. McClintock? Mr. McClintock votes no. Ms. Lesko? Ms. Lesko votes no. Mr. Reschenthaler? Mr. Reschenthaler votes no. Mr. Klein? Mr. Klein votes no. Mr. Armstrong? Mr. Armstrong votes no. Mr. Stubie? Mr. Stubie votes no. Mr. Tiffany? Mr. Tiffany votes no.
The clerk will report.
Mr. Chairman, can I make, I realize it's out of order, but
No.
well, I'm going to say
We're
it
waiting,
anyway.
we're waiting
You
for
got
the clerk's
people
report.
who are not present.
We are waiting for the clerk's report.
We're looking at the
on
video.
On the motion
Rules
to table,
require.
the gentleman will suspend. We're in the middle of a vote.
Mr. Cohen needs to vote again. We need to ask Mr. Cohen.
Mr. Cohen, how do you vote?
He has to be visible. Yes.
Okay, the clerk will report.
Mr. Chairman, there are 21 ayes and 14 noes.
In that case, the appeal is laid on the table.
Mr. Chairman.
Are there any further,
Mr.
are there any further
Mr.
amendments?
Chairman, parliamentary inquiry.
Are there any further
Parliamentary inquiry,
amendments?
Mr. Chairman.
Are there any
Parliamentary inquiry, Mr. Chairman.
Parliamentary inquiry is not in order. Are there any
Point of order.
Parliamentary inquiry.
Point of
Are
order.
there any further
Point of order,
amendments
Mr.
in the
Chairman.
nature
Point of
a
order.
substitute?
Point of order, Mr. Chairman.
Point of order.
The gentleman will state his point of order.
Pursuant to the rules, it is required, I need to find out if Mr. Cohen was actually recorded on this last vote. Was he or was he not? If he was not, he was in violation of the rules of not
The
having.
clerk
camera.
will announce whether
Mr. Cohen was not recorded.
Thank you.
Point of order, Mr. Chairman.
Gentleman will state his point of order.
Point of order is that we have people whose videos are not on. It's my understanding for them to be present and to be voting. They need to be present. I saw a number of folks where all we saw was their back screen. They vote, then they leave. Is that?
The gentleman is correct, and it is being done exactly as the gentleman stated.
And so the point of order is that that appears to be out of order and inconsistent
People
with
who
our
are
rules.
visible are being recorded and no one else. We are following the rule.
How about with the backdrop? How long do they have to stay there, Mr. Chairman?
You have to be in the room to vote either personally or by video, and that's what we're doing. I don't understand the gentleman's point. Are there any amendments? Are there any further amendments to the amendment in the nature of a substitute? For what purpose does the gentleman from Virginia seek recognition?
I have amendment at the desk.
The clerk will report the amendment.
Amendment to the amendment in the nature of a substitute to HR 2678, offered by Mr. Klein. Page 2.
I reserve the right to object.
The amendment will be considered as read. The gentleman is recognized.
Thank you, Mr. Chairman. This amendment strikes the language in the bill and replaces it with undisputed
I don't think
facts.
your mic is on. Could you?
Just hold it closer here. Mr. Chairman, this amendment strikes the language in the bill and replaces it with undisputed facts about the Mueller investigation and sworn testimony from the Obama-Biden administration officials about the investigation. Make no mistake about the purpose of this markup. The Democrats on this committee would like you to believe that the Mueller investigation uncovered evidence of collusion with Russia by President Trump. That's what they told the American people time and time again for nearly 3 years. Adam Schiff told us there was more than circumstantial evidence, but that wasn't true at all, and he knew it. An investigation that cost the American taxpayers over $30 million and involved 2,800 subpoenas, 500 search warrants, and 500 witness interviews. An investigation that had 17 attorneys, 13 of which were registered Democrats or said they were Democrats. An investigation where 9 of those 17 attorneys had donated to Democrats in political races. And what did it find? No collusion. The Director of National Intelligence, James Clapper, testified, quote, "I never saw any direct empirical evidence that the Trump campaign or someone in it was plotting or conspiring with the Russians to meddle with the election." The National Security Advisor, Susan Rice, testified, quote, "I don't recall intelligence that I would consider evidence to that effect that I saw prior of conspiracy prior to my departure," end quote. Yet here we are talking about imaginary crimes that the chairman and committee Democrats believe President Trump has committed. No matter how many changes the Democrats make to the statute of limitations, it will never change the fact that they have no evidence that President Trump has broken the laws of this country. Our cities are burning, our nation is overwhelmed by a pandemic, and this committee continues to waste its time with this political charade. I yield back.
The gentleman yields back. The question.
Mr. Chairman.
Who seeks recognition?
Mr. Chairman, over here.
For what purpose does the gentleman from Ohio seek recognition?
Move strike the last word, Mr. Chairman.
1 second. What? Oh.
Right.
Come back to that.
Yeah.
The gentleman suspend. The gentlelady from Texas.
Mr. Chairman, I insist on my point of order as to the germaneness of this amendment related to this legislation.
Okay, the gentlelady makes the point of order that the amendment is not germane, and I rule that the amendment is not germane. The point of order is well taken.
Mr. Chairman, would appeal the ruling of the chair.
I move the table.
The ruling of the chair is appealed. The motion to table is made. The clerk will call the roll on the motion to table.
Mr. Nadler?
Aye.
Mr. Nadler votes aye. Ms. Lofgren? Ms. Jackson Lee?
Aye.
Ms. Jackson Lee votes aye. Mr. Cohen?
Mr. Cohen votes aye.
Mr. Cohen votes aye. Mr. Johnson of Georgia?
Johnson votes aye.
Mr. Johnson of Georgia votes aye. Mr. Deutsch?
Aye.
Mr. Deutsch votes aye. Ms. Bass? Ms. Bass votes aye. Mr. Richmond? Mr. Richmond votes aye. Mr. Jeffries? Mr. Jeffries votes aye. Mr. Cicilline? Mr. Cicilline votes aye. Mr. Swalwell? Mr. Liu?
Aye.
Mr. Liu votes aye. Mr. Raskin?
Aye.
Mr. Raskin votes aye. Ms. Jayapal? Ms. Demings? Mr. Correa?
Aye.
Mr. Correa votes aye. Ms. Scanlon?
Aye.
Ms. Scanlon votes aye. Ms. Garcia?
Aye.
Ms. Garcia votes aye. Mr. Neguse? Ms. McBath? Ms. McBath votes aye. Mr. Stanton? Mr. Stanton votes aye. Ms. Dean? Ms. Dean votes aye. Ms. McCarcel-Powell? Ms. McCarcel-Powell votes aye. Ms. Escobar? Ms. Escobar votes aye. Mr. Jordan? Mr. Jordan votes no. Mr. Sensenbrenner? Mr. Shabbat?
No.
Mr. Shabbat votes no. Mr. Gomer? Mr. Collins? Mr. Collins votes no. Mr. Buck? Mr. Buck votes no. Ms. Roby? Mr. Gates? Mr. Gates votes no. Mr. Johnson of Louisiana? Mr. Johnson of Louisiana votes no. Mr. Biggs? Mr. Biggs votes no. Mr. McClintock? Mr. McClintock votes no. Ms. Lesko? Ms. Lesko votes no. Mr. Reschenthaler? Mr. Reschenthaler votes no. Mr. Klein? Mr. Klein votes no. Mr. Armstrong? Mr. Armstrong votes no. Mr. Stubie? Mr. Stubie votes no. Mr. Tiffany? Mr. Tiffany votes no.
Are there any other members who wish to vote who haven't voted?
Mr. Chairman? Mr. Chairman?
Yes.
Has this been recorded?
Ms. Lofgren, you are not recorded.
I vote aye.
Ms. Lofgren votes aye. Mr. Neguse, you are not recorded. Mr. Neguse votes aye.
Are there any other members who wish to be recorded who haven't been recorded? The clerk will report.
Mr. Chairman, there are 21 ayes and 14 noes.
The appeal of the ruling of the chair is approved. Is laid on the table. Are there any further amendments to the amendment in the nature of a substitute? The question then occurs on the amendment in the nature of a substitute. All in favor say aye. Aye. Opposed, no. No. The vote has already been taken. But because of an amendment, we'll withdraw that.
Mr. Chairman?
For what purpose does the gentleman from Pennsylvania seek recognition?
Oh, that was
Colorado
a
seek
deep,
recognition?
deep hurt, Mr. Chairman. Colorado.
For what purpose does the gentleman seek recognition?
I have an amendment at the desk.
The clerk will report the amendment.
I'm reserving the floor.
Amendment to the amendment in the nature of a substitute to HR 2678, offered by Mr. Buck of Colorado.
Chairman, I'm reserving a point of order.
Point of order is reserved.
Seriously?
Mr. Chairman, I'm
The gentleman is
withdrawing my point of order.
the point of order is withdrawn. The gentleman is recognized.
Thank you, Mr. Chairman. Mr. Chairman, I will be very brief. I am inclined to support this legislation, and to do so because I believe that the law should apply to all presidents. I believe that there have been many presidents in the past that have committed wrongs, and I believe that while I find the timing of this to be very suspect and troubling, I believe it is politically motivated. I do think it is a good idea to toll the statute of limitations as it applies to the president and vice president. But I think to make it absolutely clear that this is not intended in any way to be aimed at President Trump, because I think it's absolutely clear President Trump has not committed a crime while he has been in office. I think it is only fair if we make the effective date of this legislation January 20th of 2021. And so all my amendment does is make the effective date whenever the next president assumes office, and that's the only change to this bill that I would like to see in place. And I yield back.
I yield myself. I now recognize myself for purposes of debate. I oppose this amendment for all the obvious reasons why it is nonsense. For what purpose does the gentleman from Ohio seek recognition?
That was brainy.
Mr. Shabbat?
On the bill? I'll wait till the bill at this point.
Mr.
Chairman,
Shabbat,
why is this nonsense?
That's all right.
Well, Yes. Okay, Mr. Collins.
Thank you, Mr. Chairman. Well, again, I'm glad to see that we're back at it. What we have in Mr. Chairman using wonderfully interesting words to describe our members' amendments when I have lived through more amendments of his nonsense in the last 7.5 years than I care to be a part of, but that's okay. We continue this process here. You know, look, it's sort of the obvious reasons are this. The reason you obviously don't want this is because you're obviously being not genuine in the fact that this is about no other president. This is about every other president. It's about everybody that we want to talk to. This is not right. This is about Donald Trump. Just go ahead and relieve yourself. Admit it. Just admit it. You'll feel so much better in the morning. To say this is about Donald Trump. We want to make sure that we can get him. We failed in impeachment. We failed in the Mueller. We failed in life. And we're going to fail in November, but we'll try and get him then. Just help yourself out. Give yourself a little bit of encouragement and say, I have this bills and these bills today because we had nothing better to do on a Thursday in Washington, D.C. than to try and actually attack the president again. Just admit it, Mr. Chairman. Just admit it. I understand you want to and you can't because you say it's law and order and this is fair. But I agree with you. I agree with Mr. Buck. It should be applied. It should have been applied when, statute of limitations and the bill we're going to take up later, the pardons, when Bill Clinton pardoned his own brother. Should have been probably in there when Bill Clinton pardoned his own CIA director and HUD secretary. What is the problem here today is just the utter, just frank hypocrisy of just saying who is for. Just say it, because this is what it, just get on with the votes. As I've tried to remind the chairman, when I was ranking member, you have the votes. You win these. It's the way the committee system's set up. But don't continue this and call Mr. Buck, the obvious reason is just nonsense. No, the obvious nonsense here is not admitting why we're here. The obvious nonsense here is attacking the president over and over and over again, because if you truly wanted to say, no, this is not about Donald Trump, I agree with that, we don't even have the appearance of impropriety, which is not true, then we'd accept Mr. Buck's amendment. But you don't accept his amendment because this is about President Trump, because you've miserably failed for the last 19 months in everything that you've tried to attack him with. Now, you can go on and say in history and all what you want to say, no, we did. No, you didn't. History will judge the 116th Congress, especially this committee, in amazing ways. And we're going to talk at each other here for the rest of the time, but I just, I have years of counseling and counseling with people in the military and in the pastorate and everything else. I'm trying to help you here. Relieve yourself. You know you want to. Just admit it. It's about him. It's about him. I yield to Mr. Buck.
Mr. Collins, I just want to make one thing clear. When you had years of counseling, you were the counselor, not the counselee.
Exactly.
Okay.
But after this committee, after the last 19 months, who knows what's next? Because of having to deal with these arguments over and over again when the American people are sitting here wondering about what we can actually do bipartisanly about prescription drug, which it did not still pass my notice yesterday when we put the bill on the floor and abolished a bipartisan bill that Mr. Cicilline and I have worked on prescription drugs, and we put it in as a pay-for because we put the old bill in there because we had to find something to pay for a bill that'll never go anywhere. You want to talk about actually what we do in this committee? We don't talk about people. We don't talk about bipartisan things that could actually get done. We do this. So that, as I said yesterday on the floor, lose the moral high ground on prescription drugs and helping our pharmaceuticals and everything, because yesterday you blew it. You blew it when you put in the pay-for that has no hope, number one, of actually fixing anything, actually making it worse for people, but you did it and wasted it on a bill that you could have found any other pay-for. It's disturbing to me that the gentleman from Rhode Island actually worked on getting a compromise here, and we threw it away. So as we talk about this today, and we'll have a lot more. The other side will say, we're terrible, we're wrong, you're just trying to protect the president. No, the president doesn't need any protection. The truth, as I said during impeachment, is the easiest thing to go about. And we did. We won. He won because he did nothing wrong except have to endure the majority's wrath since really 2016, before he ever got elected, and especially since they became the majority last year. But as I go forward in this, you can disagree with me. You'll talk about it. We'll talk about it from here on out. But I just couldn't stand it any longer. Just trying to give you some help. Go ahead and admit These bills are about President Trump. We would have never been doing this under President Obama or President Clinton or anybody else. Just go ahead and admit it, make yourself feel better, you'll sleep good, and you can go home to everybody and say, I did it, I admitted it, it was about him. With that, I yield back.
Gentleman yields back. The gentleman from Rhode Island.
Mr. Chairman.
Mr.
Mr. Chairman, I move to
Cellini,
strike
would the
the-
gentleman yield to me for a moment?
Of course.
I thank the gentleman from yielding. I should not have been so cavalier in my obvious comment a moment ago, so I'll spell it out. This bill has nothing to do with President Trump. It simply says that statutes of limitations shall not apply to any president. The Republicans, obviously, because there's no other reason, have been talking all about President Trump because they can't imagine that he would be not found multiply guilty of every crime under the sun if the law were applied evenly, which is all the bill does. Now we have this amendment. And what does this amendment say? Only the President Trump. It says this act shall come into effect after President Trump leaves office. In other words, only President Trump of every president of the United States, past or future, should be exempt from the law. In other words, and why would they do that? Because they know that if the law is applied evenly, which is all we're trying to do, that he will be subject to every conceivable crime that he has committed, so they are trying to protect him from the prosecutions, which he so richly deserves. Because remember, all the bill says is the president should be treated like any other president. All this amendment says is no, he shouldn't. He should be favored. And why would they do that? Because they know that he cannot be sustained in a court of law. So I wish the Republicans understood that President Trump, like any other president, like any other American, is subject to the rule of law, but they do not. But we will defend the proposition that the President of the United States, any president, including President Trump, is subject to the rule of law like anybody else, and it gives me great angst and anguish to see that my Republican colleagues believe in dictatorship and are opposed to the rule of law here. I yield back to the gentleman.
Mr. Chairman.
Thank you, Mr. Chairman. I'm a little bit confused, I must confess. We just heard my colleagues for the last 2 hours claim that this bill was about Donald Trump. It's all about Donald Trump, and although the plain language of both bills apply to all presidents of either party and reaffirm the rule of law and the fact that no president of whatever party is above the law, my good friend now introduces an amendment that is all about Donald Trump. It gives him an exemption. This is exactly about one person, Donald Trump. And it's hard to square that with all the claims on the other side that we shouldn't be worried because President Trump has done nothing wrong. He's committed no wrongdoing. That old saying, thou doth protest too much. If in fact you believe in your heart that there's been no wrongdoing, then you shouldn't be worried, nor should President Trump be worried about a tolling of the statute of limitations. But this amendment, which says tolling is a good idea, every president should be accountable, but could we just hold off and not apply it to the current president, completely undermines this claim that you honestly all believe he did nothing wrong. So I'm really confused. Mr. Collins just went on and on and on about, oh, should we just admit this is about Donald Trump? This amendment is about protecting Donald Trump. The one thing we cannot do as the Judiciary Committee of the House of Representatives is do more to protect this president from accountability. That's exactly the wrong thing. And so while the legislation before us applies to all presidents, this amendment will carve out an exemption so that all of the wrongdoing, whether you think it exists or not, if in fact there is any wrongdoing, this president would be protected from accountability and liability for that. That is wrong. It's un-American. We should not do it. And although he's my good friend, I urge my colleagues to vote no on this amendment.
Would the gentleman yield for a moment?
Sure.
I just want to ask the gentleman and perhaps the constitutional law professor a quick question. Wouldn't the ex post facto provisions in the Constitution apply in this situation, and any act committed before the statute of limitations be exempt? And I say that because there are...
I'm happy to yield to Mr. Raskin to answer that.
May I just finish my question before you yield? sincere about this. I'm just asking because obviously there are some allegations that Vice President Biden has also committed crimes. So this isn't...
Reclaiming my time, I'm happy to have Professor Raskin answer that question.
Thank you for that serious question. The ex post facto clause bans the invention or creation of new substantive criminal offenses. The chairman's legislation does not create a new offense. It simply changes the statute of limitations, and the Supreme Court has held, I haven't looked at this in a while, somebody can correct me if I'm wrong, but the Supreme Court has held that alteration of the statute of limitations does not constitute an offense against the ex post facto clause.
Thank you, and with that, Mr. Chairman, I yield back.
Gentleman yields back. For what purpose does the gentleman from Texas? For what purpose does the gentleman from Arizona seek recognition? Gentleman's recognized.
Thank you very much. I'm astounded here at what we hear. First of all, this very serious amendment, and I think it's sincere because Mr. Buck is making a sincere amendment, was treated with the scintillating and well-reasoned argument against it that it is nonsense. And then trying to clarify that, the chairman said, well, it's treating all past presidents the same. Well, if that's the case, this amendment actually does treat all President Trump just like all past presidents have been treated. You're making a change. And you're making a change because of Donald Trump. You have to admit that. What Mr. Buck's amendment does is says we're going to treat President Trump as all past presidents have been treated. Whoever's the president in 2021 will be treated differently because it's not ex post facto. I agree with that. It's a change in the statute. And that's the distinction. If this is not about President Trump, why have virtually every one of you speaking out on these two bills today intoned against President Donald J. Trump? It's because it's about President Trump. Mr. Collins is right. Just admit it. Let's move on from there. We know you're not fooling me. You're not fooling the American people. But I will just tell you this. If it isn't about President Trump, and if you do want to treat him like all the previous presidents, then why oppose this amendment? Because this amendment would make it clear that he's being treated like all past presidents, and all future presidents will be treated differently. That is why this amendment is important. And with that, I'll yield to my friend from Colorado, Mr. Buck.
I thank the gentleman for yielding. And Mr. Chairman, I take exception to your initial comments that this is nonsense. It isn't nonsense. And if I had feelings, my feelings might be hurt by what you said. But being in the business that we're in, I think it's pretty unlikely that any of us have feelings. But I wanted to ask my friend from Maryland another question, because I really do think that this is a bipartisan effort to make this bill go beyond the politics of the day. My memory is that there were efforts to change sex assault statutes in various states and to extend the statute of limitations in those states. And in particular, the case that I'm thinking of involved a Catholic priest, I think. And that effort to extend the statute of limitations, that priest could not be prosecuted under that because of the ex post facto law. And that's why I brought up the ex post facto law. So,
would the gentleman yield?
I will, yes.
Thank you. I said a moment ago that perhaps I was too cavalier in calling the amendment nonsense, and a moment later I sought recognition from Mr. Cicilline, who yielded to me, and I explained in detail why I explained in detail why your amendment, in my opinion, is very wrong and pernicious. And I went through it in great detail. And I'm sorry you weren't listening. I yield back.
I was listening, Mr. Chairman. I yield to my friend from Maryland if he is interested.
Yes, but
and reclaiming my time, my time for just a minute.
Oh, just sorry.
Please make it quick, Mr. Raskin, and I'll yield to you, Mr. Raskin, to respond, because I know you want to respond. I think you can, but there's more to be said here, so please.
Don't be a professor about it, you're saying?
Yes, that's what I'm saying.
Okay, so, and I do have feelings. I might have to go talk to Mr. Collins about that. I don't know the specific case that
It
you're
might be
talking
a
about,
short
and I can go and research that, but the ex post facto clause bans the creation of new offenses and then applying them retroactively. It does not, it treats the statute of limitations as a procedural rather than substantive in nature. But I'll try to find that case you're talking about in terms of the extension of the statute of limitations in child abuse cases.
Would the gentleman yield for a moment?
Yes. I'll yield to Mr.
I have a question for the gentleman from Arizona. If this, in fact, there is a 5-year statute of limitations on federal crimes such as bribery and other corruption crimes, would this act then apply to Vice President Biden and the allegations that have been made against Vice President Biden?
In the short time I've left, I believe it would.
I thank you, gentleman. I yield back to the
And
gentleman.
I yield to the gentleman from Georgia, Mr. Collins. And I'll yield back, Mr. Chairman.
Gentleman yields back. For what purpose does the gentleman from Pennsylvania seek recognition?
I move to strike the last word.
Oh. The gentlelady is recognized.
Thank you, Mr. Chairman. I'll be very brief. I'm just puzzled by the logic of the offering of this amendment by the maker of the amendment. At first, the maker of the amendment said that he was tempted to support the underlying bill to toll the statute of limitations for presidents and vice presidents. He also argues that President Trump has broken no laws. And yet he offers the amendment which will only insulate President Trump. And by the date of effectiveness, January 20th, 2021, it also is an awareness that we will probably have a new president. Why does he do that? There's no logic to the argument behind this amendment to insulate someone he believes has broken no law. I would suggest, Mr. Chairman, it is the very powerful argument you made. That
Would the
our colleagues
gentlelady yield?
recognize, I will not yield, that our colleagues recognize there's an abundance of evidence of guilt. With that, I yield back to the chairman.
The gentlelady yields back. For what purpose does the gentleman from Ohio seek recognition? Gentleman is recognized.
Thank you, Mr. Chairman. I support the gentleman's amendment, would urge my colleagues on both sides of the aisle to support it. But Mr. Chairman, we're in the middle of a pandemic. 130,000 Americans, more than that, have died as a result of this pandemic. We've seen small businesses shuttered all over the country. People have lost their jobs, their livelihoods. Now, Congress has acted in the PPP and other things to try to help out. But in this committee, it's pretty incredible to me. We've seen schools closed. Parents aren't sure whether their kids are going to go back this fall and in what capacity that's going to happen. The American people have really gone through hell the last 5 months. But in this committee, today we consider this legislation, which is really just another effort by the majority to allege that the president has committed crimes without any evidence to support their theory. This time to ensure that the statute of limitations is suspended while the president is in office so that they can presumably continue to go after him in his second term. As our nation continues to reopen, our small businesses and our schools and our nonprofits, we could be focused today on legislation which would protect them, for example, from frivolous lawsuits, particularly for entities that adopt proper safety protocols. My other committee assignments, the Small Business Committee, where I'm the ranking member there and the former chair there, and the Foreign Affairs Committee, are focused on real issues that affect American citizens during this pandemic. For example, just last week in the Small Business Committee, we examined issues related to the next pandemic relief bill. And in it, the Small Business Administrator, Carranza, and the Treasury Secretary Mnuchin testified about the Paycheck Protection Program and other things. During it, they discussed how well that program helped small businesses and provided their insights on what we could do in the next relief bill. Their testimony really was critical in informing us on the best course of action to take so that we could safely reopen. we can do so in a manner that continues to support a bruised economy. That was the purpose of that. And that's precisely what we should be focused on in today's markup and in future hearings and markups in this committee. I hope that in the remaining months of the Congress that we can take the necessary time to focus on issues within this committee's jurisdiction that would actually help the American people and small businesses and people all over this country and nonprofit organizations as we continue to weather this global pandemic. And my concern is we continue as Mr. Collins said, to go after this president. They failed on the impeachment, they failed on this, that, and everything else, and now it's on this. We ought to be focused on issues that really affect the American people.
Will the gentleman yield?
I'm yielding actually to the gentleman from Colorado, not Pennsylvania, Mr. Buck.
I have a case for you, and I will give you the case, United States versus Stogner.
I got it.
And I want to just read that, if I may. But I also want to answer the gentlelady's question. She said, why would the gentleman offer this amendment? And I think I hold out hope with my friend from Rhode Island and some others, and not all others on this committee, but some others on this committee, that we can actually accomplish something in a bipartisan way. And I truly believe that this bill could be bipartisan if there wasn't so much rhetoric about this particular president, a president that folks on this side of the aisle believe has not committed a crime, and folks on that side of the aisle evidently believe has committed a crime. And that's fine, but let's make this bill about future presidents. Let's make this bill about serious crimes committed by future presidents, and I think you would have a bipartisan bill. And that's why I have offered this amendment. And to suggest that my amendment in some way foresees a change in president just invites the question that your bill assumes that this president will continue in office and that you seek to toll the statute of limitations on any past crimes because they would run because he would continue to be in office and not be able to be prosecuted. So again, I can certainly use empty rhetoric in response to your empty rhetoric, but I hope that we can act in a bipartisan way and accept this amendment, and I yield back to my friend from Ohio.
The gentleman's time has expired. Mr. Armstrong? Mr. Armstrong is recognized.
Thank you, Mr. Chairman, and I will yield to my friend over there in a second because I think this is a question, and I think it's not wholly determinative. I mean, there's very different answers as whether the statute is tolled already and it becomes a vested right, whether it's still pending. Even in the U.S. v. Stogner case, there's been subsequent dicta that says in certain cases they may be able to deal with this, but as somebody who is by no means a constitutional law professor but has argued the Constitution quite a bit in a courtroom, without all of the political rhetoric, I think there's a real question to be answered as to when this applies, and I think we should know the answer before we pass the bill. And with that, I yield to Mr.
Yes,
Raskin.
I very much appreciate the gentleman's courtesy here. Stogner versus California is the most on-point case we could find, and it's the one you were referring to, Mr. Buck, about a California statute that permitted prosecution of child abuse cases where the prior limitations period had already expired. In that case, there were time-barred prosecutions that were revived by a California statute, and the Supreme Court said that does indeed violate the ex post facto clause, but not a tolling statute, and this is a tolling statute. So in other words, if the bill here were to say, we're going to revive an old law from the 19th century, which we think would really rein in lawless presidents, and we're going to hold presidents accountable under that by extending the statute of limitations, then Congress would lose that case because the actionability of the prosecution has already expired. But here what's happening is simply the tolling of the statute, which has been upheld repeatedly by the Supreme Court. It would basically say we're going to freeze the frame until the president leaves office. I yield back.
Thank you, and I'll take back my time. And I agree with the first part of that. I'm not sure it's as certain in the second part, and I think these are real questions that need to be answered, and effective dates on this type of legislation. There's also outside of what the court rulings are, and then there's a public policy reason to say, hey, listen, when we're going to change a law, it is moving forward, not moving backwards. And I think in highly politically charged environments and things like that, this bill would be a lot better served with an effective date. I support the amendment's concept. I think I would rather see an effective date versus naming people and all of that, but I'm also not sure this has ever been, and I just started this last night too, a real adequate ruling on federal statutes and how those work as well. So with that, I yield to Mr. Collins.
Thank you. I appreciate it. And look, this is, for the last few minutes, has actually been substantive discussion with the gentleman from Maryland. This is substantive discussion and stuff that we need, to be talking about, because again, we're talking about laws here that come across from a very political point of view. And again, the assumption that has been brought forth a couple of times already is that the president will lose in November, which many of us do not believe he will lose. And if Mr. Buck's amendment was accepted, it would be applicable past that as well. But I think the interesting issue that the gentleman from North Dakota brought up was these need to be discussed. And here we are at a markup with no hearing, because we are moving quickly to make a political point. And I think that's the concerning part that many of us have had here. Again, I understand that time has gotten away from us, and the speaker and others have shut us down to where we don't have as much time to have hearings. And although we did have 2 weeks at the beginning of this month in which we did nothing. So maybe these could have had a hearing at that point, even if they were, the majority decided to do them virtually. But again, hearings are not important when you're just trying to get to the press release, which also brings me up to something that I would like to submit for the record. Because, look, it's harder to say it in person, but it's much easier to be a keyboard warrior. And the press shop in the majority side is pretty well answered the question for most of the majority when they put out a media alert, and this was the title of the media alert, and I would ask that it be submitted to the record. Chairman Nadler announces markup to address President Trump's abuse of pardon power. Wow. We're done. I yield back.
The gentleman yields back. For what purpose does the gentlelady from Texas seek recognition?
Mr. Chairman, I rise to strike the last word.
Gentlelady is recognized.
As I've listened to the debate, first I want to say to the gentleman that we studiously review amendments, and I know that each of us are taking special pains to consider the amendment that you've offered. But I do think it is important to dissect your particular amendment, which from the perspective of the legislation, period, it wants to defang legislation that is now in debate for utilization under our oversight responsibilities. We're acting on legislation not because of a name, Mr. Trump, the president, but because of behavior that we would not want to see for any president of the United States. There is a president, a person occupying the White House at this time, and therefore a law that deals with the question of no president is above the law is relevant to be passed at this time. In fact, your amendment signals and points discriminatorily to this legislation to make sure that someone is above the law. We all know that the Constitution says one should take care that the laws be faithfully executed. That is one of the duties of the President of the United States. In my earlier remarks, I mentioned the issue with the ambassador, the remarks made after the DACA Supreme Court decision, and I could go on, there are many more. But we've just been notified that Mr. Cohen, Michael Cohen, has been released by a judge. We know Mr. Cohen's record. He admitted such. He provided what has been known publicly, interaction with committees here on the Hill. He testified extensively before the Oversight Committee when the late Elijah Cummings was the chairman. And then he was released in this COVID-19 compassionate release. But then all of a sudden, Mr. Cohen, in a restaurant, was taken away to be imprisoned, and all that we could understand, and grateful for his lawyers, everyone has a moment of redemption, that it was because he would not cease his First Amendment rights as it relates to the administration, to be able to not talk or to not say what they didn't want him to say. That seemed to be the actions of the Attorney General and the Department of Justice, which are under the jurisdiction of the President of the United States. Now, we'll have an opportunity, I'm sure, to further investigate these issues. They may be brought to our attention. I stand on the framework of oversight, but I also hold this Constitution. It is about the behavior. That is what this legislation states. And if it is the behavior of this president, Mr. Trump, then it's about Mr. Trump. But it is not discriminating against this president. So, again, your amendment looks like it would discriminate in particular against this law, that it would not be able to apply to all who hold that particular office. For that reason, I regretfully have to oppose the gentleman's amendment, Mr. Chairman, and I yield back.
The gentlelady yields back. For what purpose does the gentleman from Texas seek recognition?
Seek to strike the last word.
Gentleman is recognized.
I really appreciate the amendment, but I'm actually struggling a little bit because I feel, as the Democrats do, that no president, no administration should be above the law. And we saw 8 years of that occurring, whether it was the IRS becoming politically active to try to suppress opposition efforts against the president's effort to be reelected, whether it was strong-arming sales, making the federal government under the Obama administration complicit in criminal activity and forcing guns to be sold to known criminals, or be sold knowing they would go to known criminals, that resulted in the loss of hundreds of lives, including our Mexican neighbors. And it just goes on. And then to find out recently, the president himself had a conference in his office where the then Vice President Joe Biden comes up with the Logan Act as a way to go after Mike Flynn, who the FBI agents that actually spoke to him did not think he had lied. So I've been concerned for quite some time that there were people that committed some of the most heinous and unscrupulous acts ever committed by a presidential administration that might be able to get away with it. And they certainly appeared to be above the law. And it would be nice, and I hear from so many constituents, how come we have, seems like a justice system that only wants to go after Republicans. And as far as Cohen, yeah, he was told what he needed to say to get off. There were others like Roger Stone that were told what he needed to say to get better treatment, and he was not willing to say that. So there's been incredible abuses, and that's why by the previous administration, I'm really torn on this amendment. And I would encourage my friends across the aisle, I hope you will stay every bit as confident as you were about Hillary Clinton winning the last election. Hope you'll stay that confident that Trump will be out of office by the end of January 2021. I would encourage you to keep thinking that. That's a good approach, I think. But at this point, I think I'm going to yield. Am I going to yield? Okay.
Yeah. I'd like to thank my colleague from Texas. So I just wanted to, I just want to throw this out there. I know there's been a debate over what's procedural and what's substantive when it comes to the statute of limitations. And I dealt with this when I was in the state Senate in Pennsylvania, because we actually had a bill that was trying to change the statute of limitations retroactively, and we found that we couldn't do it because it's viewed, once the statute is passed, it's viewed as a vested right, so you can only change it prospectively. Now, I apologize, I wasn't expecting to talk on this today, or I also would have done more research, but I found a case, Hebner versus Uniroyal, and I can give you the site. But the basics is this. I'm quoting from an article from 2017. When it comes to the statute of limitations, the issue has always been whether it's a procedural right or substantive right. The majority of states now hold that the statute of limitations are substantive. That unambiguously includes New Jersey, which in '73 was among the earliest states to reject the notion that the statute of limitations are procedural. So I know we've heard testimony from an individual from New Jersey, but I found a case that dates back to '73 that actually would point to the opposite, that it is a substantive right, and the right vests in the individual once the statute tolls. So with that, I'd yield back to my colleague from Texas. Thank you.
And I yield back to Mr. Chairman.
The gentleman yields back. The question now occurs on the Biggs Amendment. All in favor say aye. Aye. Opposed, no.
No.
No. The Buck Amendment, I'm sorry.
It's three
Question
insults.
still occurs on the Buck Amendment. All in favor say aye. Opposed, no.
No.
The noes have it. Is roll call requested? No. The amendment is not agreed to. Are there any further amendments to the amendment in the nature of a substitute? The question then occurs on the amendment in the nature of a substitute. This will be followed immediately by a vote on final passage of the bill. All those in favor of the amendment of the nature of a substitute will respond by saying aye.
Aye.
Opposed, no. In the opinion of the chair, the ayes have it. The amendment of the nature of a substitute is agreed to. A reporting quorum being present, the question is on the motion to report the bill H.R. 2678 as amended favorably to the House. Those in favor will respond by saying aye. Aye. Opposed, no. The ayes have it, and the bill is reported favorably to the House. Do I hear a motion to a roll call? Yes. Roll call is requested. The clerk will call the roll.
Mr. Nadler?
Aye.
Mr. Nadler votes aye. Ms. Lofgren?
Aye.
Ms. Lofgren votes aye. Ms. Jackson Lee?
Aye.
Ms. Jackson Lee votes aye. Mr. Cohen?
Aye, aye.
Mr. Cohen votes aye. Mr. Johnson of Georgia?
Aye.
Mr. Johnson of Georgia votes aye. Mr. Deutsch?
Aye.
Mr. Deutsch votes aye. Ms. Bass? Ms. Bass votes aye. Mr. Richmond? Mr. Richmond votes aye. Mr. Jeffries? Mr. Cicilline? Mr. Cicilline votes aye. Mr. Swalwell? Mr. Liu?
Aye.
Mr. Liu votes aye. Mr. Raskin?
Aye.
Mr. Raskin votes aye. Ms. Jayapal? Ms. Jayapal votes aye. Ms. Demings? Mr. Correa? Mr. Correa votes aye. Ms. Scanlon?
Aye.
Ms. Scanlon votes aye. Ms. Garcia? Ms. Garcia votes aye. Mr. Neguse? Mr. Neguse votes aye. Ms. McBath? Ms. McBath votes aye. Mr. Stanton? Mr. Stanton votes aye. Ms. Dean? Ms. Dean votes aye. Ms. McCarcel-Powell? Ms. McCarcel-Powell votes aye. Ms. Escobar? Ms. Escobar votes aye. Mr. Jordan? Mr. Jordan votes no. Mr. Sensenbrenner? Mr. Shabbat? Mr. Shabbat votes no. Mr. Gomert? Mr. Gomert votes no. Mr. Collins? Mr. Collins votes no. Mr. Buck?
Aye.
Mr. Buck votes aye. Ms. Roby? Mr. Gates? Mr. Gates votes no. Mr. Johnson of Louisiana? Mr. Johnson of Louisiana votes no. Mr. Biggs? Mr. Biggs votes no. Mr. McClintock? Mr. McClintock votes no. Ms. Lesko? Ms. Lesko votes no. Mr. Rauschenthaler?
No.
Mr. Rauschenthaler votes no. Mr. Klein? Mr. Klein votes no. Mr. Armstrong? Mr. Armstrong votes no. Mr. Stubie? Mr. Stubie votes no. Mr. Tiffany? Mr. Tiffany votes no.
The clerk will report. The clerk will report.
Mr. Chairman, there are 22 ayes and 14 noes.
The ayes have it, and the bill as amended is ordered reported favorably to the House. Members will have 2 days to submit views. Without objection, the bill will be reported as a single amendment in the nature of a substitute, incorporating all adopted amendments, and staff is authorized to make technical and conforming changes. Pursuant to notice, I now call up H.R. 7694, the Abuse of the Pardon Prevention Act, for purposes of markup, and move that the committee report the bill favorably to the House. The clerk will report the bill.
H.R. 7694, to provide increased congressional oversight of
Without
certain...
objection, the bill is considered as read and open for amendment at any point. I will begin by recognizing myself for an opening statement. The Trump administration has exposed certain holes in the fabric of our democracy by engaging in conduct that was once unthinkable. One area in which it has shredded basic norms that have governed our nation for centuries is in its use of the pardon power. H.R. 7694, the Abuse of the Pardon Prevention Act, would bring essential transparency and would reaffirm existing legal standards with respect to some of the most troubling abuses of the pardon power that we have seen from the Trump administration. Introduced by our colleague, Chairman Adam Schiff, and myself, H.R. 7694 would require much-needed transparency if the President issues a pardon or commutation in circumstances that may involve corrupt self-dealing, or if the President issues clemency for an offense that undermines the integrity of Congress's own proceedings. More specifically, these transparency requirements would apply if the President issues a pardon or commutation for an offense arising from an investigation that implicates the President or one of his family members. The transparency requirements would also apply if the President issues a pardon or commutation for an offense against Congress, such as perjury or false statements before Congress, obstruction of Congress, or contempt of Congress. In these circumstances, the Justice Department would be required to disclose its underlying investigative files to the chairs and ranking members of the House and Senate Judiciary Committees, and to the chairs and ranking members of the House and Senate Intelligence Committees if the offense involved an intelligence or counterintelligence matter. The Justice Department and the White House would also be required to disclose all materials relating to their considerations of the pardon or commutation. Furthermore, H.R. 7694 would make explicit what is already commonly understood, namely that abuse of the pardon power can constitute a criminal offense under the federal anti-bribery law. It reaffirms that covered public officials include the President and the Vice President. It also makes explicit that a pardon or the offer of a pardon does constitute an official act under the law, and places greater emphasis on the fact that they constitute a thing of value in certain circumstances. In other words, it reaffirms what we all know, that a president cannot trade pardons in exchange for personal favors. It is a sad day in our democracy when Congress has to make explicit that a president cannot abuse his pardon powers for corrupt and self-serving purposes. But President Trump has been fixated on the pardon power as an instrument for his own personal benefit since early in his administration, and it is important, therefore, to reaffirm certain basic principles. The record makes clear that the President repeatedly dangled the possibility of pardons for witnesses like Michael Flynn, Paul Manafort, and Roger Stone, as well as for Michael Cohen, before Cohen chose to cooperate with law enforcement. Only then did the President change. These were all witnesses in an investigation implicating the President personally, as well as several of his family members. President Trump delivered on his promise to Roger Stone. who was convicted by a jury for obstruction of Congress, witness intimidation, and multiple counts of making false statements in connection with an investigation that implicated the president himself in potential criminal conduct. In fact, Stone has bragged how he resisted pressure to flip and testify against the president. And the president has publicly congratulated him for having the guts not to cooperate with federal law enforcement. This is the president using mafia terms. Now Stone has been rewarded, just as in the mafia movies, has been rewarded handsomely for his silence by the president. This legislation is not just about President Trump, however. It is about the presidency. To be sure, no president before Trump has made such troubling use of the pardon power. But for better or worse, President Trump has made it necessary to make explicit rules that his predecessors followed as matters of common sense and basic respect for our constitutional system. And his pattern of behavior has made several principles clear. Those principles are reflected in this legislation. First, Congress should be entitled to scrutinize potential abuses of the pardon power, including in instances where pardons were potentially issued for corrupt purposes. You do not need to take my word for it. Consider the words of then Representative Lindsey Graham in 2001, when Congress was investigating President Clinton's pardon of Mark Rich. As Graham said to a reporter, quote, "The role of Congress is part of a check and balance scheme. The power to pardon comes from the Constitution. It is important that Congress, even though we can't change the outcome, create a historical record to make sure that if it is an abuse of power, that it not happen again. And our role in the check and balance scheme is to review the conduct of the most powerful man in the country, regardless of party." I would note that then Representative Graham was correct then, and he is still correct. I would note that when then President Clinton pardoned Mark Rich, a pardon I did not support, the Republican Congress did engage in aggressive oversight, quite properly, and the White House and the Justice Department officials did testify before Congress. Second, for similar reasons, Congress has a vital interest in scrutinizing pardons for offenses that undermine the integrity of Congress's own proceedings. Consider the case of Roger Stone, who was convicted for lying repeatedly to Congress, for obstructing Congress, and for intimidating a witness before Congress. When the president pardons such offenses, he threatens Congress's ability to exercise our own constitutional functions, including our vital function of conducting hearings and obtaining testimony from witnesses. Third, while Congress is limited in its ability to circumscribe the pardon power directly, nothing in the Constitution allows the president to use the pardon power as an instrument for committing a crime. As Attorney General Barr himself acknowledged during his confirmation hearings, existing law makes it a crime for the president to offer a pardon in exchange for witness silence. H.R. 7694 simply reaffirms that abuse of the pardon power can form the basis of a bribery scheme. These principles should apply to President Trump and to any future president. No president should feel entitled to use his or her pardon power for personal benefit or in a manner that undermines Congress. And no president should trade on the pardon power as part of a bribery scheme. It is unfortunate that we have reached a point where this legislation is necessary. But we must not shrink from doing our duty to ensure that no president, now or in the future, can abuse his or her office in the manner we have witnessed in recent months and years. I strongly urge support of H.R. 7694, and I urge the committee to report it favorably to the House. I now recognize the distinguished ranking member of the Judiciary Committee, the gentleman from Ohio, for his opening statement.
Thank you, Mr. Chairman. The bill alters the pardon power granted exclusively to the president by the Constitution by establishing a new standard for President Trump's use of the pardon power, one to which no other president has been held. It would require that the president and the Attorney General produce to Congress documents and information relating to certain pardon decisions. This way, the bill opens up the president's pardon power to inquiry and examination by the Congress. But the Constitution is clear. Article 2, Section 2 states that, quote, "The president shall have power to grant reprieves and pardons for offenses against the United States." Congress has no authority to alter the president's pardon power. Former Attorney General Janet Reno recognized this truth, telling President Clinton that Congress has no authority whatsoever to review a president's clemency decisions, because granting clemency pursuant to the pardon power is unquestionably an exclusive province of the executive branch. And in fact, our chairman agreed with her. The chairman quoted Senator Graham, but I'll quote the chairman himself. In 2001, in a Constitution subcommittee of this committee, Chairman Nadler said, quote, "No power whatsoever to put any restrictions or conditions on guidelines on the president's pardon power. None whatsoever." But that is exactly what this bill does by requiring the president and the attorney general to produce to Congress materials relating to pardons. It allows Congress to review these decisions. Once again, Democrats are setting another standard for this president that differs from previous presidents. Democrats won't talk about how President Clinton used the pardon power to pardon his brother for a felony cocaine offense, or how President Clinton pardoned Susan McDougal, a business partner who went to jail for refusing to answer grand jury questions about President Clinton. Democrats won't talk about how President Clinton pardoned CIA director and HUD secretary, how he granted clemency to 16 members of a terrorist group, or how he pardoned prominent Democrat donor, as others have mentioned, Mr. Rich. Democrats won't talk about how President Obama pardoned James Cartwright, his former vice chairman of the Joint Chiefs of Staff, who was convicted of making false statements to federal prosecutors. They won't talk about President Obama's pardon of Chelsea Manning, U.S. soldier who passed top secret information to WikiLeaks. You won't hear Democrats talking about how President Trump uses pardon power to effectuate the goals of our criminal justice reform that I think almost everyone on this committee supported. You won't hear Democrats talk about President Trump's pardon of Jack Johnson, who was convicted by an all-white jury in 1920 for violating the White Slave Traffic Act. Civil rights groups petitioned previous presidents to issue this pardon, but only President Trump actually did it. You won't hear Democrats talk about Alice Johnson, first-time offender sentenced to life in prison for drug offenses. President Trump commuted her sentence. And you probably won't hear Democrats talk about these uses of the pardon power. Instead, you will hear them talk about President Trump's decision, as the chairman just did, regarding Roger Stone. Never mind the fact that Stone's prosecution was an outgrowth of the Obama-Biden administration's weaponization of the Justice Department against the Trump campaign. Never mind the fact that 25 agents in tactical gear conducted a pre-dawn raid on Stone's house to arrest him. Never mind the fact that CNN cameras just happened to be present to capture that moment. Never mind the fact that special counsel prosecutors, including Aaron Zelinsky, who testified here last month, sought an excessive sentence against Stone, and we know it was excessive because the judge agreed with the reduced sentence that was then submitted to the court. Democrats refuse to let go of their obsession with investigating and attacking President Trump, and this bill would give them another avenue for more investigations, more sham hearings, and more phony outrage. Mr. Chairman, in 2001, that Congress had no power whatsoever, your words, no power whatsoever to interfere with President's pardon power. President Trump has rightly used the pardon power to grant clemency to individuals who received an unjust sentence or prosecution, and that's why we should oppose this legislation. I yield back.
The gentleman yields back. Without objection, all other opening statements will be included in the record. I now recognize myself for purposes of offering an amendment in the nature of a substitute. The clerk will report the amendment.
Amendment in the nature of a substitute to H.R. 7694.
Without objection, the amendment in the nature of a substitute will be considered as read and shall be considered as base text for purposes of amendment. I now recognize myself to explain the amendment. This amendment in the nature of a substitute makes a minor change to the title of the bill, renaming it the Abuse of the Pardon Prevention Act of 2020. Otherwise, it does not change the substance of the bill in any way. I urge all members to support the amendment. I yield back the balance of my time. I now recognize the ranking member, the gentleman from Ohio, for any comments he may have on the amendment. The gentleman yields back. Are there any amendments to the amendment in the nature of a substitute?
Mr. Chairman.
For what purpose does the gentleman from Maryland seek recognition?
I have an amendment at the desk, Mr. Chairman.
The clerk will report the amendment.
Amendment to the amendment in the nature of substitute to H.R. 7694, offered by Mr. Raskin of Maryland. Add at the end of the bill the following.
Gentleman is recognized.
Thank you, Mr. Chairman. My amendment treats any attempt by any president to pardon himself or herself as immediately null and void, a legal farce which deprives no court of jurisdiction in a prosecution of the president for federal offenses. No president has ever tried before to pardon himself, and indeed not even a king has ever attempted that brazen deceit, so far as I can tell from the historical record. But we do live in days when long-settled norms are being destroyed with alarming frequency. So now is the time to make clear what has always been understood as the very basis of our rule of law. No person is above the law, and no president of the United States of any political party can insulate himself from the consequences of his past or future crimes by, quote, pardoning himself and thus exempting himself from the rule of law. The controlling principle here was articulated not by me, as my friend Mr. Jordan would say, but by James Madison in Federalist Number 10, the most important essay in American constitutional history and philosophy. And I quote, "No man is allowed to be a judge in his own cause." And Madison explains specifically why. No man is allowed to be a judge in his own cause because his interest would certainly bias his judgment and not improbably corrupt his integrity. He goes on to say that, quote, "Men are unfit to be both judges and parties at the same time." And here Madison speaks not of the most confused and depraved of men, but of men of sound mind and high ethical character. This principle that you cannot be a judge in your own case is so entrenched and replete in our constitutional system that it hardly needs to be explained. No judge at any level of our system, whether federal or state, from the Supreme Court down to administrative law judges or parking judges, may rule on a case in which he or she is a party himself or herself, or has a direct personal interest. And this is despite the fact that Article 3 says nothing explicit about it. The Supreme Court treats the Madisonian principle as constitutionally anchored, self-evident, and controlling. Judicial recusal is required even when a judge is not an actual party in a case, but when his judgment can be presumed to be biased because of heavy campaign spending on behalf of one of the parties in the case. In an extremely illuminating decision called Caperton versus Massey in 2009, the Supreme Court found that a West Virginia Supreme Court of Appeals judge ruled illegitimately in a decision where one of the parties in the case spent $3 million to get that judge elected. Even though the defendant and the judge argued that the Constitution nowhere explicitly banned such a relationship, and even though the party was certainly exercising his First Amendment rights to spend that money, the court nonetheless found that a self-interested and biased judgment is an intolerable violation of our Constitution and due process under both the Fifth and the 14th Amendments. A presidential self-pardon is an even greater threat to the Constitution and rule of law. The president's core responsibility is to take care that the laws are faithfully executed, but a president who can pardon himself for past and future offenses can instead take care that the laws are routinely violated and escape scot-free with immunity and impunity. A self-pardoning president takes powers even greater than those imagined by the kings that our country was organized to overthrow. Here's Madison again in Federalist 47 on a public official claiming all powers to himself. Quote, "The accumulation of all powers, legislative, executive, and judicial, in the same hands may justly be pronounced the very definition of tyranny." The very definition of tyranny. So, in our system, Mr. Chairman, in our system, nothing can control an uncontrollable president or govern an ungovernable criminality. But this amendment makes clear that in our legal system, our prosecutors, our judges, our law enforcement officials cannot be turned into a nullity by a president treating the pardon power as a mockery and a fraud on the public. Either a self-pardon will nullify the rule of law, or the rule of law will nullify a self-pardon. This amendment will make clear that the nullity is the self-pardon, not the rule of law itself. I invite all of our colleagues to treat this not as a partisan matter, but rather as a basic principle going to the heart of the American legal and constitutional system. I yield back.
Mr. Chairman.
Gentleman yields back. For what purpose does the gentleman from Ohio seek recognition?
You want to go, Mike? I'll yield to the gentleman from Louisiana.
Gentleman yields.
I thank the gentleman from Ohio. Mr. Chairman, I oppose this amendment because it's plainly unconstitutional, and my con law professor over there and I could have a great dialogue about this. But let's just look at the plain language of the Constitution itself. It's very clear. Article 2, Section 2 states that, quote, the President shall have the power to grant reprieves and pardons for offenses against the United States, except in cases of impeachment. If the President did not have the power of self-pardon, then it's obvious that the framers could have and would have added the phrase, and cases involving himself. But they didn't do that. Congress has no authority to alter the President's pardon power under the Constitution. It's not just Republicans who are saying that. As has been noted, in 1999, under a different administration, then Attorney General Janet Reno recognized this plainly. She wrote a memo, famously, that's been published everywhere, sent to President Clinton that said, quote, Congress has no authority whatsoever to review a president's clemency decisions because granting clemency pursuant to the pardon power is unquestionably an exclusive province of the executive branch. The Supreme Court has noted on several occasions that the pardon power is within the exclusive authority of the executive branch. In Ex parte Garland, the court noted, quote, this power of the president is not subject to legislative control. In U.S. v. Klein, the court noted, to the executive alone is entrusted the power of pardon. Justice Kennedy in Public Citizen v. Department of Justice stated that the pardon power is committed to the exclusive control of the president. Even Chairman Nadler himself, as has been noted here this morning, has acknowledged that Congress has, quote, no power whatsoever to put any restriction or conditions or guidelines on the president's pardon power. Of course, that was in 2001, in a very different time under a Democrat president. Democrats are again setting another standard for President Trump that differs from previous presidents. And just honestly, I mean, without any hyperbole, the hypocrisy is just staggering. By the way, if you look up the actual statistics, what are they? If you look at real facts, President Trump so far has been involved in 36 pardons and commutations. But you know how that compares to other presidents in the modern era? George W. Bush had 200 in his terms. President Clinton had 457, which includes some scandalous pardons of his family and friends and even a cabinet member, as has been noted this morning. And President Obama was the king of pardons and commutations. While President Trump has had 36, President Obama had 1,927. And there's a lot of controversy in those as well. Look, the point here is that the Democrats are wasting our time. This amendment, the underlying bill, are political farces aimed solely at undermining this particular president's constitutional authority, and they're doing it for political gain. We ought to be focusing on the very critical, important issues that truly matter to our constituents, but we're not doing that. Instead, we're engaging in these partisan games. Instead of working with Republicans to pass legislation that we could all agree on, Chairman Nadler is squandering critical committee business days to take political jabs at President Trump and other administration officials. Rather than focusing on significant bipartisan legislation for the American people, Chairman Nadler has once again chosen to prioritize his what looks to be a personal vendetta against the president. I know this dates way back to their time in New York, but they're now using committee time to hash this out. Democrats continue to assert without evidence that the president has committed crimes. But as has been noted this morning, the Democrats' biggest theory, allegations of collusion with Russia during the 2016 election, turned up empty after Special Counsel Mueller's investigation. After nearly 4 years and countless wasted hours of partisan investigations, Chairman Nadler is again refusing to let go of the collusion delusion. We'll say it again many times today because it's true. No matter how many of these hearings we have, the underlying facts and the text of the Constitution will never change. It's time the other side accepts that. We oppose this amendment. I urge my colleagues to agree.
I appreciate it. I would just say this in the last 45 seconds. I appreciate the gentleman's remarks. The Constitution says you can't do this amendment. The Supreme Court in several cases has said you can't do this amendment. And Democrat officials, including the former Attorney General in the Clinton administration and the current chairman of the Judiciary Committee, say you can't do this amendment. You can't do this amendment. It's unconstitutional. The Constitution itself, the Supreme Court several occasions, and the current chairman of the committee said just a few years ago, you can't do this. That's why we should oppose it. With that, I yield back.
The gentleman yields back. Votes have been called on the House floor, so we will now recess until the votes are concluded. We will resume immediately after votes are concluded. The committee stands in recess. The committee will come to order. We will now resume consideration of the Rankin Amendment. First, without objection, a statement from Ms. Garcia will be entered into the record, along with an op-ed by Robert Mueller entitled "Roger Stone Remains a Convicted Felon, and Rightly So." I now recognize myself in support of the Rankin Amendment. I strongly support the Rankin Amendment, which makes explicit that a president has no
Would
authority
the gentleman yield?
to pardon himself for his own crimes. The Constitution itself would appear to cover this. Article 2, Section 3 requires the president to take care that the laws be faithfully executed, an obligation that is incompatible with the president pardoning himself and thus placing himself beyond the reach of those bylaws, of those very laws. The president's constitutional oath to faithfully execute his office also prohibits this kind of naked self-dealing. All four witnesses who testified in this committee's hearing on the pardon power last year, including the witness invited by my Republican colleagues, agreed that self-pardons are incompatible with the Constitution. The Justice Department previously embraced this view as well. In an opinion issued just days before President Richard Nixon resigned from office, DOJ's Office of Legal Counsel advised that President Nixon could not pardon himself based on, quote, "the fundamental rule that no one may be a judge in his own case," close quote. Unsurprisingly, President Trump alone seems to disagree. In fact, he has claimed an absolute right to pardon himself. And if his prior use of the pardon power is any indication of how he may use it in the future, we have little choice but to take him at his word. So it is all the more important that we in Congress exercise our own constitutional responsibility to speak clearly on this issue and reaffirm that the effect of any self-pardon will be null and void. There are, of course, limits on Congress's authority to restrict the president's abuse of the pardon power. Courts have interpreted the pardon power broadly, but the issue of a self-pardon is unique and is fundamentally at odds with all notions of justice. Although the legal community is virtually unanimous in its opinion that the president may not issue a self-pardon, the one person with the power to do so has not gotten the message. It is therefore incumbent on us to make this point explicit. By speaking firmly on this issue, we may deter this or any future president from attempting such an unprecedented move. And should this issue ever reach the courts, judges and justices will have the benefit of our views as well. As with other aspects of this bill, it is unfortunate that it has become necessary for us to make explicit these basic principles of fairness and common sense. Any president who commits a crime and then pardons himself for it would display open hostility to our nation's system of laws. Such blatant corruption and self-dealing cannot be tolerated in a constitutional democracy. Mr. Raskin's amendment is a thoughtful, common sense, good government measure that all of us should be able to support. I strongly urge the committee to adopt it. Who else seeks recognition?
Mr. Chairman, I have a point of order.
Mr. Buck is recognized. For what purpose does Mr. Buck seek recognition?
To state my point of order.
The gentleman will state his point of order.
Mr. Chairman, on 3 separate occasions, you mentioned that it was Mr. Rankin's amendment. We have no Mr. Rankin on this committee, and therefore I think the amendment is out of order.
Will the gentleman yield?
It's not a point of order. Who else seeks recognition?
Mr. Chairman.
Who else seeks recognition? Mr. Tiffany is recognized.
How's that, Mr. Chairman? I'd like to move to strike the last word.
Gentleman is recognized.
Because what is before us today is clearly unconstitutional. But first, I'd like to thank you for the warm welcome. Thank you for the warm welcome, Mr. Chairman, as well as our ranking member, Mr. Jordan, for his kind words coming here from Wisconsin, where I just left our legislature. And I really expected that we would be dealing with issues seriously here in this great body, here in the Congress of the United States of America, running for, my campaign for the special election, which I succeeded in May 12th. That's one of the things I cited frequently was being able to go to this great august body that is an emblem of freedom across the world, the Congress of the United States. And then we come into a hearing like this, expecting serious discussion, and it's really disappointing. And I could tell last night that it wasn't going to be serious with a quote from you, Mr. Chairman, from, I believe it was 2001. In part, no power whatsoever to put, Congress has no power whatsoever to put any restriction or conditions or guidelines on the president's pardon power. So clearly this is just political. And these two bills today should have been put together under the heading of the Congressional Harassment Act, because that's clearly what Congress is doing at this point. Now, I take very seriously legislative authority, and serving in the legislature in Wisconsin, we did take power back to the legislature that had been ceded to the executive branch excessively over the past decades. And I believe that's happened in Washington, D.C. also. But we should not be seeking to take authority that is not ours under the Constitution. What we have before us today is clearly unconstitutional. But if you want to go down this route, then let's go back to January of 2017. Let's go back to the meetings that have been fully documented by serious journalists here in Washington, D.C. The meeting that President Obama and Vice President Biden were in, where the plan to harass this president was hatched. It's possibly the greatest scandal, political scandal, that we've seen in the history of our country, and it is in plain sight. It would be wonderful if our media would cover it. You have the authority to bring the truth to America. Because while Americans view Congress in a dim light at this point, they want the truth, and Americans can handle the truth. What went down that day in early January of 2017 when Vice President Biden said, let's use the Logan Act to get at President-elect Trump, deserves much more scrutiny than it's had. So if you want to have this hearing today on issues like this, let's be fair. Americans understand fairness. They would like to see all the truth put before them. They may not like it, but Americans can handle it. So let's put it all on the table, Mr. Chairman, for Americans to see how the Congressional Harassment Act, the Congressional Harassment era began way back in January of 2017. I yield my time.
The gentleman yields back. For what purpose does Ms. Jayapal seek recognition? Well, I'll call on Mr. Cohen then.
This is Congressman Cohen. I move to strike the last word.
Gentleman is recognized.
Well, I heard some of the discussion before we broke, and got my a little bit there, I guess. Some of the discussion before we broke, and there was some discussion, and I agree the pardon power is pretty straightforward in the Constitution, that just says the president's got the pardon power. And some people say because of that, you can't really do anything about it. Well, you know, the Constitution says everybody's got freedom of speech. It doesn't say anything about defamation. It doesn't say anything about not yelling fire in a crowded theater. There are certain places that constitutional provisions are changed because of the understanding that they weren't just supposed to be inviolate, and that as times change, things are looked upon differently. Freedom of speech was not absolute. There are court decisions that affect it, and they understood that it wasn't. And as far as what the framers saw and what they thought, you know, the framers didn't say anything about self-pardons. They sure didn't. But the framers didn't say anything about space flights to Mars, men on the moon, airplanes, or television, because they weren't around and they couldn't imagine them. And they couldn't imagine a president who would commit crimes and think about pardoning himself because he had committed crimes and could go to jail. George Washington, they didn't think about somebody like that or any of the other founding fathers. They were not people who committed crimes or appeared to. They were never named individual one. You know, when you're named individual one, that's a real hint that you might have committed a crime. You're not somebody like George Washington who never told a lie and who would say, yes, I cut down the cherry tree. So times have changed. Things change. We had a hearing in the subcommittee on the Constitution, Civil Liberties, subcommittee in March. We had one earlier too, in 2017, and we had 4 particular professors of expertise on this, and they all said that the president could not pardon himself. Andrew Kent of Fordham Law School testified a self-pardon would seem to be utterly inconsistent with the historical meaning of the faithful execution duties placed on the president. Justin Florence of Protect Democracy testified the Constitution's take care clause requiring the president to take care of the laws be faithfully executed, and its oath clause requiring the president in an oath of office to swear faithfully execute the office of president, each prohibit the president from using any of the other powers available to him, including the pardon power, to place himself above the law. Carolyn Frederickson of the American Constitution Society noted President Nixon's Department of Justice issued a memorandum in August 74 addressing the propriety and constitutionality of a self-pardon and concluded the president cannot pardon himself. That conclusion is still in effect and is still binding on the executive branch, despite President Trump's claim that he has absolute power to pardon himself. Even the Republican invited witness, James Stiffner, a professor emeritus at George Mason, yes, George Mason, not George Washington, testified that though the issue of self-pardons has not been legally or constitutionally settled, arguments against allowing self-pardons seem to outweigh the arguments in favor. It's clear from the record established by our subcommittee that the president's pardon power is broad, but it's not unlimited, and the Constitution must read to preclude self-pardons. That's why I suggested a constitutional amendment to ban self-pardons, pardons of family members, pardons of cabinet members, administration, and of campaign staff. Like Roger Stone, old commuted Roger Stone, who's buddies with WikiLeaks. You know, they hate leaks, but they like WikiLeaks. Anyway, I don't know if the language we've got is necessary, but it doesn't hurt. And it's certainly clear that the predominance of legislative scholars think that the president cannot self-pardon, and he certainly shouldn't. And the founding fathers, Trump. Nobody envisioned Donald Trump. This is all neutral.
The gentleman yields back for our purposes, Mr. Big Seek recognition.
To strike the last word.
Gentleman's recognized.
Thank you, Mr. Chairman. The arguments that we've heard in favor of this amendment really are unpersuasive. First of all, there was reliance on Federalist 10. That's misplaced for a couple of reasons. Number one, Madison is not talking about the exclusive and heretofore plenary power to pardon or grant clemency of the president that is recognized in Article 2. And that's been recognized through case law throughout this country's history. B, Madison is speaking of judges, and including that example of being a judge, Madison discusses specifically a collection type of case, judge, creditor, debtors, in a collection dispute. An analogy of judges to the president's exclusive and plenary power is not pertinent here. That's because a judge, even a judge, has limited powers, unlike the president's authority where pardons and clemency are concerned. There's no court, there's no attorney general opinion, other than the one that you've cited, which is inapposite to this case, are concerned. Number two, this amendment actually raises separation of powers issues because, quite frankly, all the way back to the founding of this country, the power to pardon in the president has been viewed as plenary or without limitation. An attempt now to put a limitation on that power crosses the line that separates the legislative and executive branch. Thirdly, much of the argument that we've heard here, including from the our last friend across the aisle that spoke, in spite of the fact that this rhetoric against, there's been rhetoric against President Trump, but it's this notion that it would be unseemly for a president to pardon him or herself, that it would be gross and boorish, perhaps. But you can make no mistake that while such an act might be so, the Constitution does not proscribe or prohibit obnoxious conduct. And there is no authority here. Otherwise, we would prohibit and proscribe, for instance, if you wanted to prescribe this conduct, you would say, well, we find certain kinds of speech objectionable because it is offensive. That is not That's not allowed. That does not, the Constitution actually protects some kinds of obnoxious behavior. So if your argument is this would be obnoxious or gross or boorish, where is your constitutional authority to set that aside?
Would the gentleman yield?
Yeah, go ahead. Yeah, I'll yield for a minute. Go ahead.
So, first of all, thanks for those questions about it, because
I didn't have any questions, but you may address.
the whole thing struck me as a big question. But I want to address the point that Madison in Federalist 10 was talking about judges. He definitely was not talking about judges. Your argument is improved if you say he was talking about legislators, because all in the context of saying the legislature should not be judge in its own case. But that just proves the point that he's talking about everybody within the federal system, that no man is allowed to be a judge in his own case because it will corrupt.
I'm going to reclaim my time here. Good. And here's why. Because when you start, yes, he's talking, Article 10 is about factions and parties, and that's where that goes. When you begin talking about judges, and that's what you brought that up, not me.
Well, I can read you the passage. It's about legislators.
I have the time here.
Would the gentleman yield for question?
No, I'm responding, okay? So when you start talking about judges, and you use that as your example, as an analogy to no president can set aside or pardon, you didn't go on and go to the next paragraph below that where Madison is specifically talking about judicial conduct and how absurd that would be. The distinction, which apparently you didn't catch, and so I'm going to reiterate it for you. The pardon power is plenary under Article 2. It means it's virtually without limit. There are no constraints on it. A judge and the legislator does not have such plenary power. That is the distinction that you failed to make. And that is the distinction.
Would you yield for one other question?
That is the distinction I am making here.
Would the gentleman yield?
I'll yield to Mr. Raskin.
Okay, so the Constitution also does not explicitly say that the president may not render a pardon in return for money. It doesn't say he can't sell a pardon. Do you believe that the president therefore can sell a pardon?
I'm reclaiming my time. No, I don't think you could sell a pardon. I don't think you can sell that. Your amendment doesn't get to that.
Well, but another one
Nor
did.
does your argument get to that. Nor does your argument get to that.
You just said that we have to be bound by the fact that it doesn't say anything about it.
I didn't yield back time to you. And now my time's gone.
Will the gentleman yield now? Will the gentleman yield?
Mr. Chairman, I have no more time to yield.
Okay. Ms. Jackson Lee is recognized. Would she yield to me, please?
I'd be happy to yield to the chairman.
Thank you. I just want to point out the logical absurdity of what Mr. Biggs was just saying. Mr. Biggs said that there is no limit to the pardon power. The president can pardon himself. The president can pardon himself in advance. And there's no limit. So the president, according to Mr. Biggs, could announce on television today that he planned to murder every member of Congress or every inhabitant of the state of Arizona. And he could proceed to do that, and he pardons himself, and there's nothing anybody can do about it. Now, there's a principle in American law that no man is law unto himself, which Mr. Biggs apparently thinks is not correct. There's a principle that you can't commit murder, which Mr. Biggs apparently thinks is not correct, as long as you're the president. The president can murder anybody.
Will the gentleman...
I will not yield. The president can murder anybody, can do anything, and as long as he pardons himself, he is held harmless. That is not the way the American Constitution works. There's a principle in American law, many principles, that, Jefferson and Lincoln both said that the Constitution is not a suicide pact. Mr. Biggs thinks the Constitution is not only a suicide pact, but a murder pact. The president can do anything he wants, pardon himself in advance, and no one can punish him for it.
Point of order.
No one can do anything. This is absurd. This is absurd in the extreme. And I'm simply pointing out the implications of what Mr. Biggs is saying. Now, either you say that although the Constitution gives a pardon power, it cannot give it in advance, as most constitutional scholars think it cannot, and it is not unlimited. Or else you give the president, any president, now most presidents wouldn't use it, perhaps this one would, but most presidents certainly wouldn't go out and commit murder and mayhem. But under Mr. Biggs' theory, anyone could, and there's nothing anybody could do about it. This is absurd in the extreme. I yield back to the gentlelady.
Would the gentlelady yield over here, just for a moment, so I could shed some light on that?
No.
You won't yield?
My time is short, Mr. Johnson. I thank you.
Your mic, your mic.
My time is short. Thank you so very much. Let me try to use the time as succinctly as I can. Let me remind my colleagues in the Constitution of the Take Cares Clause, it is the responsibility of whatever power the President has under the Constitution that it must be done carefully under the laws, and that is the pardon power. Remember, the pardon power is a tool of mercy as a remedy for miscarriages of justice and for instances of unfortunate guilt. It is not a get-out-of-jail-free card. It is not a card to take an alleged perpetrator or a perpetrator who intimidates witnesses, who affronts and confronts the legal system and makes a mockery of it, as evidenced by the President's dear friend of whom he pardoned, Mr. Stone.
Mm-hmm.
It is also to recognize, when we think of pardon, that we think of a pardon to give mercy, not to receive mercy. If the President chooses, as our chairman suggested, to murder throngs of individuals and to self-pardon, that does not fit with the constitutional duties to uphold the law. But he could do that under the interpretation of my friends on the other side of the aisle. As we said earlier, this is not about this president in terms of if it was another president, we would not be here as well. But Mr. Trump's behavior evidences that this particular legislation, this statutory fix, is evident and apparent. Our clarification is that it is not suggesting that bribery is not the legitimate law and would be attuned to his actions. We're not saying that. What we're saying is bribery exists. Bribery would adhere to the president and as well anyone else that works for his administration. And as we have seen in Mr. Cohen, who has just been released on the basis of retaliation that the judge determined, Mr. Cohen rejected a pardon. Why? Because it was a quid pro quo. You get a pardon, and then that would say a bribe, and you speak kindly of us, or you don't speak of us at all. You don't tell your truth. How much more can we give evidence to? And in fact, have a circumstance where there is a clear abuse of power, and this committee and this Congress does not render oversight on behalf of the American people. It is not for me. It is not for any member of this committee. We have no pardon powers. It is for the American people to recognize that the actions rendered under a Constitution are fairly issued according to the intent of the Founding Fathers and as well the intent of the Constitution of the United States. Fair, unfettered use of the pardon powers to benefit those who deserve mercy, and finally, who have been the victim of unfortunate guilt. None of those circumstances are before us today. I yield back.
The gentlelady yields back. Ms. Lesko.
Thank you, Mr. Chair. I move to strike the last word.
Gentlelady's recognized.
Thank you. I yield my time to Congressman Biggs.
Thank you. I thank the gentlelady for yielding time to me. Just a couple of comments. First of all, much of what you said, Mr. Chairman, you ascribed motives to me. When you said Mr. Biggs thinks that murder can be pardoned, I never said that, never discussed it. You're ascribing motives. Sometimes I think you did it correctly. Sometimes I think you crossed the line. When I tried to raise a point of order, as often happens, I was ignored. But I raised that now because I think that was outrageous on your part.
Would the gentleman yield?
No, I won't yield. Would you yield to me? No, you never yielded to me when I asked. I don't mind going to a logical absurdity, as you just did. That is arguendum ad absurdum. That's fine. Go ahead, get out there. But I would ask you, if that is
your standard. You say you're saying President Trump's going to, maybe he's the kind of guy, if he's the kind of guy that's going to murder a bunch of people, but he's going to pre-pardon himself. That is ludicrous, of course. Because I find myself saying, would it then be appropriate to pardon a murderer in any situation? Would it be appropriate to pardon a terrorist in any situation? And I think to myself, well, we actually have precedent of terrorists being pardoned by President Obama. You're the one who brought it up. Instead of acknowledging that you actually there are some logical flaws. You haven't talked about plenary power. The gentleman from Maryland has. I appreciate that, because it's more of a rational dialogue. But when you move to this logical idiocy, this move so far out there, and you're talking about murder as if this president has committed murder or might commit murder, in reality, we've actually had pardons of terrorists and murderers over the years by presidents. This is absolutely one of the most bizarre defenses of this violation of separation of powers, this amendment, that I've seen here. And that's saying a lot, because we've seen a lot of absurdities in the last 3 years. With that, I'll yield back to the lady.
Thank you, Mr. Biggs, and I yield the rest of my time to Mr. Johnson.
I thank the gentlelady from Arizona, and I just wanted to interject a bit. I can't see Mr. Raskin's face from way over here, but the answer to a lot of the questions, some that were raised by Mr. Cohen on video, some that were raised by the chairman, are answered very specifically in the Constitution. These are absurd questions, and these are wild-eyed hypotheticals, but even that, it's all answered in the Constitution, and the answer is really simple. The pardon power is not something that this branch of government has any say in whatsoever, as the chairman has noted in previous administrations, and the courts have as well. That's why it says in Ex parte v. Garland, the Supreme Court noted this power of the president is not subject to legislative control. But the answer to all the wild-eyed hypotheticals and all the absurd notions and everything that you guys have thrown out, and the answer to what Mr. Cohen said earlier is that there is a check on that power. It's the third branch of government. It's the court. It's the Supreme Court, right? Just because we don't have the authority to limit it doesn't mean that it's unlimited. The Constitution's very specific. It gives that role and the ultimate responsibility for it to 9 justices on the Supreme Court. That is the check. And that is why the founders, who did, of course, understand the abuse of power notion, they wrote about it eloquently in the nation's birth certificate, the Declaration of Independence, and everything that guided their framers' notions about drafting the Constitution and setting up these 3 articles and doing it exactly the way they did it precisely because they knew that executive authority could be overrun, that men were subject to total corruption. And so they put these safeguards in the Constitution. They have served us well. They will continue to serve us well. And the reason they don't want the legislative branch to meddle in these things, and the reason they wrote it exactly as they did, is because they knew the Supreme Court would be the check on it. I think you guys know that, but it doesn't serve your political purposes right now, and that's why we're doing this soundbite hearing and wasting our time. It is objectionable. It has reached the point of absurdity, and that's why this argument is appropriate. I'm sorry. It's a waste of the American people's time. I yield back.
Gentleman yields back. For what purpose does Ms. McCarcel-Powell seek recognition?
Mr. Chairman, I move to strike the last word.
Gentlelady is recognized.
Thank you, Mr. Chairman. I rise to support H.R. 7694, the Abuse of the Pardon Prevention Act, and here's why. We have witnessed this president use the pardon power to keep his allies from facing justice and to keep the public from hearing the truth. He has dangled pardons to those who will protect him and refused to cooperate with law enforcement. He has suggested it for Michael Flynn and to others. Just a few weeks ago, we saw the commutation of Roger Stone's sentence despite his egregious crimes. And as a reminder, let's go back a little bit. Roger Stone was convicted by a jury of his peers for 7 felonies. He was convicted of obstructing justice and lying to prosecutors. The judge in his case rightly pointed out that He was not prosecuted for standing up for the president. He was prosecuted for covering up for the president. Shortly before he was arrested, Stone bragged that he would never roll on Donald Trump. And just hours before his sentence was commuted, Roger Stone said Trump knows I was under enormous pressure to turn on him. It would have eased my situation considerably. But I didn't. They wanted me to play Judas. I refused. Because Stone refused to cooperate with our system of justice, because he protected the president, Stone was rewarded. He was allowed to escape justice because he made a deal with the president. The Mueller investigation outlined the circumstances clearly. The report points out that the president's conduct could also be viewed as reflecting his awareness that Stone could provide evidence that would run counter to the president's denials and would link the president to Stone's efforts to reach out to WikiLeaks. Keep quiet and you will be rewarded. Even Attorney General Barr said that Stone's prosecution was righteous. This is how democracies fail. I have said it many times. When dictators hold themselves and their cronies above the rule of law and above the people, democracy fails. The pardon power is fundamental to our government and the check and balances that guide our democracy, but this power must have limits. When a president abuses the pardon power to protect himself or as a bribe to those who refuse to cooperate with law enforcement, there has to be consequences. This bill gives the people transparency when the pardon power is used for self-serving reasons. This bill keeps the president accountable to the people by preventing self-pardons. I support this bill and Mr. Raskin's amendment to hold all presidents to account and preserve our government for the future. I yield back.
Well, would the gentleman yield?
Yes, I yield, Mr. Raskin.
Thank you very much. It was stated by a few of our colleagues that the power granted to the president under the pardon clause is unlimited, absolute, and plenary, bearing no possibility of regulation by Congress, which would, of course, mean that we cannot make it a crime to bribe the president for a pardon. That is not a hypothetical thing. There have been lots of bribes for pardons throughout American history. So under the argument, under the logic of the argument that's being offered to us, under the Constitution, the president could sell pardons openly without any legal consequences, and then he could pardon himself for any future prosecution for having sold the pardons or for any other crime. Because if it bears no legislative regulation at all, then the president could just say on the way out of office, on the last day of office, on January 20th, and I pardon myself for all past offenses and all future offenses that I may commit. And I think that is the necessary and logical implication of the argument being made. You say that's absurd. Hey, as a matter of fact, I would have thought it absurd 2 years ago if someone told me that the president would be dispatching secret paramilitary squads into the cities of America to put down protesters, nonviolent protesters. I would have thought that was absurd, but this is not so absurd. And as a matter of law, it's certainly not absurd. Or put it this way, if you think it's absurd, it's only because you accept that it's all right for us to consider it bribery. And you think it's okay to prosecute a president for accepting a bribe or someone else for offering a bribe in return for a pardon.
Would the gentleman yield?
Able to answer that. Yes, but it's not my time, but thank you very much.
Would the gentleman
I yield a second to the chairman.
Thank you. I totally agree with what Mr. Raskin just said, and it's essentially what I said a few minutes ago and what Mr. Biggs said I was biased for saying. If you concede to the president the power, the unlimited power to pardon himself in advance, and that no one has authority to stop him, then he could, as Mr. Raskin said, commit bribes, one after the other, or as I said, machine gun people in the streets. And there's no power to do anything about it because there's an unlimited power to pardon for himself, for any crime, etc. That's an untenable view. It's absurd. I simply pointed that out, for which Mr. Biggs said that I was casting aspersions on him. I was not. I was simply casting aspersions on his logic. But that is the inherent, and that's why we need this bill, to make it clear that a president cannot, no president, there's nothing to do with Trump, no president can commit any crime with impunity and to get away with it because he pardons himself in advance. I yield back to the gentlelady.
Thank you, Mr. Chairman. My time is up.
Mr. Chairman?
I yield to the gentleman from Ohio.
I'll tell you what's absurd. What's absurd is the gentlelady from Florida talked about refusing to work with law enforcement in her comments, talked about the rule of law. Is anyone watching what's going on around our country for the past several weeks? Talking about refusing, talking about not administering the rule of law, not working with law enforcement. Look at what Democrat mayors in every major urban area in our country are letting happen. Portland, 56 days has been burning. That's 8 straight weeks. And what do Democrat leaders around the country do? They write letters to DOJ. They defund the police. They complain about the president. You know the last time there was a Republican elected mayor of Portland? 1956. Somehow what's happening there is Republicans' fault. Somehow what's happening there is the president's fault. They write letters, they complain, they defund the police, and when they fail to protect citizens, like what happened in St. Louis, and 2 citizens protect themselves, those individuals get charged with the crime. And the gentlelady from Florida talks about the rule of law and the Trump administration refusing to work with law enforcement. Go talk to the 49 officers Friday night in Chicago who were attacked. Go talk to the police chief in Chicago who says, we would welcome help from the federal government. My guys are getting attacked by the mob, and Democrat officials in our city won't step forward and help them.
Would the gentleman yield?
No, I'm telling you what's going on. The gentlelady's the one who brought up the rule of law and working with law enforcement. We see what Democrats mean by that. We see in New York, the mayor of New York, cutting $1 billion from the police, getting rid of the plainclothes unit. We see what's happened in Los Angeles, cutting the police $250 million. That's what we see. And we get lectured about the rule of law, about protecting people, about standing up with our police officers. Give me a break. Give me a break. Last time there was a Democrat mayor in some of Republican mayor in some of these towns. Like I said, you got to go back 50, 60 years, but somehow it's Republicans' fault. Holy cow. I yield back.
Gentleman yields back. Gentleman yields back. What purpose does Mr. Nagu seek recognition?
Move to strike the last word.
Gentleman's recognized.
Thank you, Mr. Chairman. I rise today in support of Chairman Schiff's bill. I think that it is a bill that provides for any number of eminently reasonable provisions with respect to disclosure of information in terms of how the president dispenses with his pardon power. I support my colleague, Professor Raskin's amendment with respect to self-pardons. I certainly think that the restatement of existing law as it relates to ensuring that executive officers in our government, the president, the vice president, are subject to our bribery laws as outlined in 18 U.S.C. 201 is a thoughtful reminder given the developments of the past few months. I would say this, I appreciate the constitutional debate that both sides have been engaged in for the better part of the last few hours. I think Mr. Johnson's point with respect to Mr. Raskin's amendment regarding the ability of the president to issue a pardon for himself or herself is well taken. And obviously this is an area where there is some ambiguity, and legal scholars on different ends of the political spectrum have come to different conclusions as to whether or not that power ultimately rests with the president. I would say this, however, in defense of Mr. Raskin's amendment. First, the notion that Congress cannot take any steps to impose any type of limiting principle with respect to a power that is outlined or enumerated in the Constitution, I think is misplaced. Congress has certainly done that on numerous occasions. The Impoundment Act of 1974, the War Powers Act, there are a variety of different laws that Congress has passed to be able to ultimately restrict, refine, clarify powers that have been enumerated in the Constitution. In addition, I would say that with respect to the power being plenary in nature, and I know Representative Biggs has articulated that point as well, there are a variety of different powers assigned to both the Congress and the chief executive in the Constitution that on their face appear unqualified. Of course, the Commerce Clause perhaps being the most salient example in terms of congressional power, and yet those powers have been limited over the course of many, many years, in that case, by the court. But putting all of that aside, I recognize Mr. Johnson's point, and given his fidelity to being a textualist and so forth, that perhaps he believes that issuing a pardon, the president rather issuing a pardon to himself or herself, would be constitutional. I disagree on that point, and that's why I think this bill is so important. But what I have failed to hear yet from my colleagues, and I would give them an opportunity to opine on this point, is whether or not they believe it would be proper or appropriate, or whether they would concur in my assessment that a president attempting to pardon himself for crimes he may have committed would be unconscionable, which is precisely why it has not happened in the 243-year history of our republic, why no president of the last 45 has attempted to do so. Of course, the issues we debate today, they are not abstract, they're not divorced from reality. As my colleague, Representative Muscarell-Powell, outlined, this president just recently commuted the sentence of a longtime friend who had been convicted of lying to Congress, to this body. So I ask, and I'm happy to yield to my colleague, Mr. Johnson, or any other of my friends on the other side of the aisle, if they would agree with me that it would be unconscionable for this president or any other president to issue a pardon to themselves for crimes they may have committed. I'm not asking whether you believe it's constitutional. I'm asking you whether you think it is right. Representative, my colleague from Colorado, Representative Buck.
I absolutely don't think it's right. I don't think it is appropriate, and that does not make this more constitutional. I think we can agree that a president pardoning himself is inappropriate and something the American people would take great umbrage with. But
thank you. And Representative Buck, reclaiming my time, I appreciate you saying that, and I certainly hope that your colleagues will share your sentiment.
Will the gentleman yield?
With that, I see my time is yield.
Will the gentleman yield?
Oh, Representative Gohmert, I'll yield to you, of course.
No, I agree. That would not be right, and we should all be upset about it. So,
Would you yield?
Would you yield for me?
I yield back to the chairman.
Would the gentleman yield to me?
I yield to the chairman.
Well, I'm glad to hear that the two, Mr. Biggs, I think it was, or Mr. Buck and Mr. Gohmert agree, because that's the entire bill. There's nothing else in the bill.
We don't need a bill to do it.
And I'll yield back to the gentleman.
And I yield back the balance of my time.
Gentleman yields back. For what purpose does Mr. Gohmert seek recognition?
strike the last word.
Gentleman's recognized.
You know, I agree. It would not be right. But we have heard about the absurd repeatedly in the name of trying to be logical when it wasn't at all. Sometimes we have to go back to basics that people get to Washington and they forget. Very, very basic lessons. The police powers are supposed to mainly rest with the state and local government, with the people, according to the 10th Amendment. There are exceptions to that. The federal government can protect federal property, which this president is doing. But to call up the example, say the president had a whole bunch of people murdered, no matter what we do in this committee, it will not prevent any president from being prosecuted by the state or local government wherein the murders were created. That is basic 101 criminal justice. And even though my colleagues, some of them on the other side of the aisle, have been trying to pull all the police power into the federal government where it doesn't belong, And you don't have to, so if you wouldn't do that, you wouldn't have to worry about a president pardoning himself for murder, because he would have nothing to do with those charges. They'd be state charges. And if it happened in Texas, it would be styled the state of Texas versus that person. And the president couldn't stop it. So that's just ridiculous to even be talking about that. But what is just as outrageous, perhaps more, you talk about a little guy named Roger Stone, who would never have been prosecuted if he were not a friend, not a close friend, but a friend of the president. Now, but what you have in the preceding administration is people literally getting away with murder and not being held to account, not being called in here and held to account even by Congress for outrageous things that they have done. And so, which is worse, giving yourself a pardon or making sure as president you or anybody in your administration is not prosecuted, so that you can say after you're president, well, we never had any scandals in my administration. Well, they were covered up pretty well, but hopefully some of that's about to change. And I think it is. So anyway, we're not going to have a president pardoning himself. The people, the American people, would be outraged, and I would be one of those. I wasn't thrilled when Gerald Ford pardoned Richard Nixon. We should have finished that up, I think, but and let the chips fall where they may. But we're here today, and if you guys will quit trying to federalize every local crime, you'll never have to worry about the things that you're bringing up for examples. And I would like to yield the last minute, 20 seconds, to my friend from Arizona, Mr. Biggs.
I thank the gentleman for yielding, and I appreciate his comments. My notes that I had written down actually correspond a little bit with what you said, but with respect to my friend from Colorado, I'd already said the fact that something is obnoxious or pernicious, such as perhaps pardoning yourself, is just that. It's obnoxious and pernicious. That does not make it unconstitutional. That's the point. And the remedies are multiple here. We've talked about, Mr. Johnson talked about the courts. There is another remedy that the legislative branch has. It's called impeachment for high crimes or misdemeanors. That's what you can do, even if they no longer sit as president. The last part I had written down here is state and local crimes. That is the other area that someone who committed a crime would be held accountable for. Those are the responses. The power, you've not convinced me that the pardon power is not plenary. You just haven't. And that's fine. I mean, we can have those differences. But the point is, I just don't find your arguments today persuasive. Thank you. I yield back.
The gentleman yields back. For what purpose does Ms. Jayapal seek recognition?
I move to strike the last word, Mr. Chairman.
Gentlelady is recognized.
Thank you, Mr. Chairman. It is a sad day in history that we're forced to remind the president and the American people that the president may not abuse his pardon power and may not pardon himself. In the history of this country, we have not seen what we're seeing today with this president, the complete corruption of the sacred power of the presidency, the disregard for the welfare of the people, and the complete and total arrogance of using every tool of power given to the president by the people for his own personal gain and ego. Chairman Schiff introduced this bill to highlight the tremendous danger to our Constitution when President Trump and his associates seem to be floating the idea of abusing presidential pardon power to undermine Special Counsel Robert Mueller's investigation or any other investigation into Trump's business family associates. That concern came to fruition earlier this month, as some of my colleagues have mentioned, on July 10th, when Trump commuted the sentence of his longtime friend and associate, Roger Stone, for his convictions for obstruction, 5 counts of false statements, and witness tampering. But this is a pattern where the president pardons his friends, follows through of the dangling of pardons before those who could testify against him, as we saw during the House's impeachment trial, a trial which did, by the way, lead to the impeachment of Donald Trump, something that will be recorded in our history books. Roger Stone's pardon raises the exact abuse that George Mason worried about on June 18, 1788, when he warned about a president who might someday, quote, establish a monarchy and destroy the republic, a president who would subvert justice for our democracy for all Americans by using powers given to him to protect the people who swear fealty to him at all costs. Consider this: almost every single one of President Trump's pardons or commutations have had some kind of personal or political connection to him. Conrad Black, convicted of obstruction and fraud for pocketing $60 million that should have gone to shareholders, pardoned on May 15, 2019. Mr. Black is a friend and supporter of the president who published a glowing biography of President Trump titled Donald J. Trump, a President Like No Other. Racist former Sheriff Joe Arpaio, who built a career as an anti-immigrant hardliner, convicted for criminal contempt for refusing to comply with court orders related to his illegal policing work by a federal judge in Arizona, pardoned on August 25, 2017. Arpaio was a staunch Trump supporter who appeared at one of Trump's first campaign rallies in 2015. And Roger Stone, sentenced to 7 felony crimes, and the day before he was to report to prison to serve his sentence, Donald Trump commuted his sentence, a giant thank you gift basket wrapped up with a bow, and sending a message to anyone else corrupt enough to push for a death of justice and a death of democracy. This is not the purpose of presidential pardons, and the framers thought that they had put in place all the checks and balances that they needed. But you see, the Constitution still assumes that the people elected to office on either side of the aisle take their responsibilities seriously. It assumes that the Senate acts as a separate and distinct body, not one that simply dances like a puppet to the strings of a corrupt White House. And if you doubt this, just look at the lives that Republican behavior has cost America in less than 8 short weeks. On May 18, 2020, there were 83,000 deaths in the United States due to COVID. Today, there are 140,000 deaths in America due to COVID. That is 57,000 deaths in just 8 weeks. That is 7,125 deaths per week and over 1,000 deaths per day of Americans, simply because Republicans have refused to hold this president accountable for anything, for not telling people to wear a mask. They're not being held accountable for COVID, not for abuses of power, not for the undermining of our institutions, and certainly not for the destruction of our Constitution and our democracy. This bill reminds the American people that we in government are the holders of their sacred trust conveyed to us by the people. It reminds the American people that no president can refuse to give testimony or obstruct Congress, and no president may use a self-protective pardon to bury an investigation and place himself above the law. Thank you, Mr. Chairman. I yield back.
The gentlelady yields back. For what purposes of Mr. Buck seek recognition?
Move to strike the last word.
Gentleman's recognized.
Thank you, Mr. Chairman. Mr. Chairman, in case anybody in America is watching, and I hope that they are not, we have had some of the most outrageous statements, I think, and I would like to just clarify the record for my colleague to say that the United States of America is a democracy should send chills up the spines of everyone in this room and the few that are watching this hearing. One of our founding fathers, John Adams, said, remember, democracy never lasts long. It soon wastes, exhausts, and murders itself. There never was a democracy yet that did not commit suicide. That is precisely why our founders created a republic. They've created a republic. In fact, this body, Congress, is one of the examples of that republic. We are elected by our constituents to come to this body and to represent our district, to represent America. The day that we hold a general referendum on every single issue that is before us, as they do in democracies, is the day that we lose the character of this country, and frankly, the day that we start to commit suicide as a nation. And unfortunately, we have been moving in that direction for the last 60, 70 years, and it is dangerous. My friend from Maryland, Mr. Rankin, said that we are now using federal agents to protect, sending, the president is sending federal agents to various states. He is doing so to protect federal property. There is absolutely nothing wrong with the President of the United States protecting federal property. And in fact, one of the more absurd pieces of legislation that was passed in this committee and on the House floor was this D.C. statehood idea. And the reason that it is absurd is because in Philadelphia, when Congress was meeting in Philadelphia, there were protesters that were protesting because they had not been paid their pensions as Revolutionary War veterans, and they shut down Congress. And the governor of that state refused to allow Congress to meet, refused to break up the protests because of political reasons. And George Washington, James Madison, John Adams, Thomas Jefferson met and decided that we needed a federal district that would be protected by federal forces so that no state politics would interfere. We now have state politics interfering with the protection of federal property by Democrat mayors, Democrat governors who are standing down and allowing vandalism and other acts on federal property. And this president will not tolerate taxpayer money being wasted and threatening lives by those, and frankly, the cover-up of that information by Democrat governors and mayors. And so I applaud this president. I applaud him for taking a stand and protecting us and protecting federal property and protecting our republic from what is, I think, just gross mismanagement, negligence, and in some cases, crimes by governors and mayors in the cities and states across this country. And I hope that the president continues to protect federal lives, federal property, and the lives, frankly, of all Americans that are just terrified by what is going on in this country.
Mr. Boat, behind you. Yeah.
I yield back to my friend from Texas.
Yeah, I just wanted to, so articulate, I envy that. But to address another absurdity about, gee, he could pardon himself just to avoid impeachment. Let me read you again what the Constitution says, Article 2, Section 2. Talking about the president, he shall have power to grant reprieves and pardons for offenses against the United States. Wow, and look at this next line. Except in cases of impeachment. So it's an absurdity to bring that up. He can't pardon himself such to avoid impeachment, so you can rest easy and don't have to make that one up again. Thank you. I yield back.
The gentleman yields back. For what purpose does Mr. Johnson seek recognition?
I move to strike the last word.
Gentleman's recognized.
Thank you, Mr. Chairman. We're here today because we have a reckless, lawless, and out of control coronavirus that has robbed, cheated, and stolen the entire time it's been on the scene. And just like the coronavirus, President Trump is out of control and everybody knows it. And the American people want us to do something about it. And that's why we came here today. Correction, not everybody knows it. Everybody knows the president is out of control except for my friends on the other side of the aisle who are in that diminishing number of people who would watch our president shoot somebody in the back on Fifth Avenue in broad daylight, and they would let him get away with it because of their fear about what he would say about him. So we are here today, ladies and gentlemen, to pass reasonable legislation to preserve the integrity of the pardon power. And this president has abused the pardon power over and over again by requiring basic transparency in cases where a reprieve benefits the president or hinders a congressional inquiry. This bill would prevent this out-of-control president from interfering with investigations into his or into his unconstitutional actions. The power to grant pardons and reprieves is one of the greatest trusts we as Americans place in our president. As partners in our social contract, we endow this authority with the faith that the president will use it to prevent the egregious miscarriage of justice. Alexander Hamilton argued in Federalist 74 that the power to pardon was an important element in our newly drafted Constitution because of the potential for the judicial system to be unnecessarily cruel. Last week, the president had the opportunity to use this tremendous power to prevent the executions of 3 men, and he refused to do so in the face of legal requests by the men's lawyers, entreaties from a victim's family, and outcry from a reasonable society. Before last week, the federal government hadn't executed a death row inmate in 17 years. And that's because we here in society have moved away from the brutality and finality of capital punishment. To commute the sentences of these 3 men to life in prison would have been a very presidential thing to do, but instead, Donald Trump helped out his friend Roger Stone by commuting the sentence of his buddy. President Trump sent a message to the American people that he only cares about protecting those who are close to him, even when they've committed crimes, and especially when those crimes were committed in furtherance of protecting him, the president, from investigation. Mr. Schiff's legislation would peel back the curtain and shine some sunlight on an opaque process whose purpose has been abused by this administration. And I intend to vote yes on this bill, and I urge my colleagues to do so. And with that, I will yield back.
The gentleman yields back. For what purpose does Mr. Swalwell seek recognition?
I move to strike the last word.
Gentleman's recognized.
It's been suggested by my colleagues on the other side that it's ludicrous to suggest the length Donald Trump would go to protect himself or his friends. Well, that's interesting because before Donald Trump was elected president, most of us would have said it's ludicrous to welcome foreign interference from the Russians and ask them to hack your political opponent. Before Donald Trump was elected president, most of us would have said it would be ludicrous to ban Muslims from entering the United States. Before Donald Trump was elected president, most of us would have said it would be ludicrous to cage children and separate them from their families. Before Donald Trump was elected president of the United States, most of us would have said it would be ludicrous for someone to praise white supremacists and say there are good people on both sides of a protest. Before Donald Trump was elected president, most of us would say it would be ludicrous for a president to commit 10 obstructive acts of justice. Before Donald Trump was elected president, most of us would say it would be ludicrous to leverage $390 million of your taxpayer money to have a foreign government help you cheat an upcoming election. Before Donald Trump was elected president, most of us would say it would be ludicrous to pick a fight with the National Hurricane Center. Before Donald Trump was elected president, most of us would say it would be ludicrous to use your own property for a G8 summit. Before Donald Trump was elected president, most of us would say it would be ludicrous to use chemical weapons on peaceful protesters. Before Donald Trump was elected president, most of us would say it would be ludicrous to send federal militarized police into America's cities. You know, most presidents face political pressures from time to time, and sometimes we've seen presidents do what is pessimistically called wag the dog, but that usually involves declaring war on other countries. It would be ludicrous to declare war on Portland, Chicago, or Oakland. Before Donald Trump, most of us would say it would be ludicrous to fight harder for Confederate monuments than to fight a global pandemic. Before Donald Trump was elected president, most of us would say it would be ludicrous to allow the Russians, if credible allegations are true, to pay bounties for the precious lives of U.S. soldiers. We have to plan for the ludicrous, Mr. Biggs, because the president is ludicrous. Worse, the conduct at the White House is corrupt. But we kind of knew this was coming, and my colleagues on the other side kind of knew it was coming. They were warned that Donald Trump was, quote, a pathological liar, utterly immoral. They were warned, quote, Trump is a con artist. We need to end this lunacy. They were warned, quote, Donald Trump is a race-baiting, xenophobic religious bigot. They weren't warned that by Democrats. Those were the words of Ted Cruz, Marco Rubio, and Lindsey Graham. Donald Trump is not always going to be president. So it shouldn't be crazy, it shouldn't be divisive for us to say that Donald Trump and no president should be able to pardon themselves. That should not be something that we are even debating. It should be voice voted. But here we find ourselves. And before Donald Trump was elected president, if you told me that my Republican colleagues would be defending a person's ability to pardon themselves, I would have said, that's ludicrous. Mr. Chairman, no person is above the law. Not this president, and what we are seeking to do here to repair the damage that the wrecking ball of Donald Trump has taken to our democracy is to make sure that not only is he not above the law, that no future president is ever above the law. And I yield back.
The gentleman yields back. For what purposes Mr. Shabbat seek recognition?
Move to strike the last word, Mr. Chairman.
Gentleman is recognized.
Thank you, Mr. Chairman. Article 2, Section 2 of the Constitution provides that no president shall have power to grant reprieves and pardons for offenses against the United States, except in cases of impeachment. And that power has generally been regarded as broad and unfettered, or as the Supreme Court put it in Ex parte versus Garland, not subject to legislative control. Now, Mr. Chairman, some years back, quite a few years back, I chaired the Constitution Subcommittee of Judiciary, and you were my ranking member for 6 years. And I know it's already been mentioned, something that you said, but I think it bears saying it again. You said at the time, Congress has no power whatsoever to put any restrictions or conditions or guidelines on the exercise of this power. And that was referring the presidential power to pardon. Now, one big difference, obviously, between that time back then and the time now is we had a Democratic president back then. We now have a Republican president. And another difference is that when we were talking about highly suspect pardons that President Clinton actually issued, he had actually issued these pardons. We're now discussing conspiracy theories about pardons the majority worries that President Trump might issue. So it's really incredible to look back then and back now and what's being said now versus what was being said back then. Some of the pardons that President Clinton issued were highly questionable, and we were in the majority back then, but we didn't attempt to change the rules to restrict that president's, that Democratic president's Article 2 powers, and you shouldn't do so either. It's highly irresponsible. Throughout our nation's history, there have been pardons or commutations which have been exceptionally unpopular. The most notable example in recent memory may well be the pardon of Richard Nixon by then President Gerald Ford. In fact, as a young man, relatively young man of 22 back then, and having voted for Richard Nixon when I was 18, I actually, 4 years later, voted for Jimmy Carter. To justify his decision, his being President Ford's decision, he claimed that a trial would have only served to further divide our nation. That decision, in the end, cost him, I believe, and most people believed at the time, the presidential election in 1976. It cost him my vote at the time. Nevertheless, his decision was wholly within the powers of the president and not subject to congressional oversight or control. By the way, looking back these many years later, I'd have to say that President Ford was probably right and I was probably wrong. I was certainly wrong to vote for Jimmy Carter. The bill we're considering today has the opposite effect. It aims to, rather than bring us together, to further divide our nation at a time when we should be united in our effort to keep the American people safe and healthy. And you know, there was an allegation made earlier, and it's been commented upon again, about this president somehow inappropriate or illegally or unethically sending federal law enforcement into American cities. Well, as the ranking member said earlier, look what's going on. I mean, Portland in particular, and if any of you haven't heard our acting Homeland Security head describe what's actually happening there, I mean, for 50-plus nights now, you have basically peaceful protesters during the daytime, but then Antifa and the anarchists, the thugs, those people that really want violent overthrow of this nation, in reality is what they want, they're out there. They're trying to burn the building down. They're trying to harm the people that are in there. They're throwing explosive-type fireworks. They're tearing down pieces of wood that are trying to protect the windows in the place and setting them on fire. It's the most irresponsible, outrageous behavior that you've ever seen. And the governor out there and the mayor out there won't do a thing. And that's why it's absolutely responsible and appropriate for federal law enforcement to protect a federal building, since the local officials that ought to be doing that just absolutely refuse to do it. So I would strongly encourage folks to look at the facts here and make sure that they don't fall to this business about this president's acting unethically in that respect. Certainly not, and I think I've used all my time, so I yield back.
The gentleman yields back. Mr. Shabbat, you were right to vote for Jimmy Carter. For what purpose does Ms. Dean seek recognition?
I move to strike the last word.
Gentlelady is recognized.
And I'll be brief. It is a sad and serious day when we have to examine whether or not this president or any president could pardon him or herself. But all you have to do is look to the words of this president. It was in June of 2018 when he tweeted, and I quote, "I have the absolute right to pardon," in all caps, "myself," end quote. So then I compare that against the very concise amendment offered by Mr. Raskin of Maryland. And it simply says, the president's grant of a pardon to himself or herself is void and of no effect, and shall not deprive the courts of jurisdiction or operate to confer on the president any legal immunity from investigation or prosecution. I'm relieved to hear at least two of our colleagues on the other side who agree with that statement, that a president does not have the absolute right to pardon him or herself. So I look forward to them voting yes on the Raskin amendment. Remember, and I want to build on what Representative Jackson Lee talked about. Let's remember what a pardon is. It is an expression of mercy. It is not, geez, you're my friend, you covered for me, I'll get you out of jail, I'll commute your sentence, I'll give you a free pass. And I promise you one in the future too. That's not what mercy is. Mercy is something, a higher calling than justice. I love the lines from The Merchant of Venice. Shakespeare wrote in a beautiful argument offered by Portia, a woman lawyer, I might add. The quality of mercy is not strained. It droppeth as the gentle rain from heaven upon the place beneath. It is twice blessed. It blessed him that gives and him that takes. And earthly power doth show likest gods when mercy seasons justice. This president does not seem to understand what the pardon power is all about. He sees it as a get-out-of-jail reward for a loyal crony, corruption, pass. It is not. Pardoning, offering mercy to someone, is a far higher calling. I urge a yes vote on the Raskin Amendment, and I yield back.
Gentlelady yields back. What purpose? The gentlelady yields back. What purpose does Mr. Armstrong seek?
I move to strike the last word. Thank you, Mr.
Gentleman is
Chairman.
recognized.
And prior to talking about this, I just want to say something to my good friend from Colorado about the restriction on the Commerce Clause. I would argue almost only after it was expanded exponentially, but that's a different conversation for a different time. A pardon is a power in this context granted solely to the president with one specific exclusion, and that is impeachment. It doesn't say including but not limited to impeachment. It says except impeachment. And we keep bringing up the Mueller investigation and the Bob Mueller investigation and all of this like it is this bastion of integrity. And I think my side of the aisle would be completely comfortable relitigating that entire investigation, because every single day as more documents are declassified, we understand where that started, where it's come, and where it really began. As early as this week, more information came out about the Steele dossier and how it was completely, the people who were using it knew that it was completely false and a farce. But we're talking about pardons in this context, in this unique place, and I think it's important to know that before Donald Trump was president, Thomas Jefferson pardoned somebody solely for the purpose of getting them to testify against Aaron Burr. Prior to Donald Trump being president, Warren Harding was actively engaged in selling pardons. Prior to Donald Trump being president, Franklin Roosevelt pardoned political allies. Prior to Donald Trump being president, Harry Truman pardoned political allies. Prior to Donald Trump being president, Richard Nixon pardoned Jimmy Hoffa. Prior to Donald Trump being president, Bill Clinton pardoned his brother. This is neither unique, regardless of how you feel about these. And I go back to the investigation and Roger Stone and how the underlying investigation was so full of holes that you wonder why we prosecuted anybody out of that. But also, I will recognize a lot of Roger Stone's problems are Roger Stone problems. So when you are an agent provocateur, sometimes you deal with those issues. But we act like this is an immediate constitutional crisis that has never happened before, and we put this pardon power in a place for the purpose of this hearing and for purpose of political sound bites that, quite frankly, it doesn't belong. If you want to change the pardon power, get a constitutional amendment. That is the appropriate way to do it. If you think there is a problem with how a president deals with any pardon, take it to the third branch of government, which is the courts. But we simply do not have the authority to do this in this matter. It is clear in the Constitution, and I agree with my colleagues. We are wasting our time. And with that, I yield. I yield to my friend, Mr. Biggs.
I thank the gentleman for yielding. I think, just to riff on some attack earlier, it's ludicrous to imagine a president pardoning his brother who's been convicted for felony cocaine-related offenses. It's ludicrous to believe that a president would pardon a business partner and key witness against their wife, the First Lady, in a scandal. It would be ludicrous to think that the president is going to pardon a CIA director and a HUD secretary, or that 4 people that were convicted during an investigation, 8 more people convicted in a follow-up investigation would be pardoned by a president, or that a president would pardon a huge Democratic donor who's living abroad trying to avoid being brought back for justice. That's ludicrous. Mr. Swallow, those things are ludicrous, except for those actually happened. The hypotheticals that we've heard here today are merely hypotheticals full of hyperbole. President Clinton did all of those things, but he did more. He granted clemency to 16 members of the Armed Forces of National Liberation, a Puerto Rican terrorist group. We think of President Barack Obama and those he also pardoned. The issue here is not the hypothetical you've brought, the issue is not, geez, you're my friend. No, the issue is the Constitution itself, and that's what we've been discussing. The issue is whether you believe that the pardon power is plenary or not. That is really the bottom line. And it's obvious we're not going to reach a accord on that issue, in spite of the fact that the courts have reached an accord on that issue. And what they've said is exactly the opposite of your position today. With that, I'll yield back to my friend.
And Gentleman yields back. What purpose does Ms. Scanlon
I
seek
got
recognition?
5 seconds.
Gentleman, continue.
That's okay, I'll yield back.
Gentleman yields back. What purpose does Ms. Scanlon seek recognition?
I move to strike the last word.
Gentlelady is recognized.
I did want to spend just a second speaking in defense of states that have Democratic governors and Democratic mayors, because we have some of both in Pennsylvania. And I don't know where my colleagues across the aisle or the president, quite frankly, are getting their facts. It must be the United States of Fox News or something, because we do not have rampant lawlessness in Philadelphia, in Pennsylvania, in the other cities that I represent. And for that reason, we would be extremely resistant to having federal law enforcement, federal intel officers, federal troops sent to make a political point for the president. And with that, I would yield to Mr. Raskin.
I thank the gentlelady from Pennsylvania very much, and I'd love the chance to address a few things that are floating around out there. One is, I believe Mr. Biggs just said that the court has said the exact opposite of what we're arguing with this amendment. No president has ever attempted to pardon himself before or tried to. So there is no direct authority on the proposition that's being contested today. Nothing like it. Now, I think a clear majority of this committee believes it would be unconstitutional for the president to violate the Madisonian principle that no one under our system of government can be the judge of his own case. And I think a majority, therefore, believes that it would be unconstitutional for the president to attempt to pardon himself. A supermajority, a very big majority, clearly thinks it would be wrong, because that's a bipartisan majority. Several Republicans have said that they definitely think it would be wrong. I want to try to convince our good friends across the aisle who believe it would be wrong for the president to pardon himself to embrace the proposition that it would be unconstitutional too. Now, I understand that the most potent argument on the other side is that Article 2 appears to offer what several members have described as an unlimited or plenary power of pardon to the president. They've not been able to explain then why a president or people who bribe the president for a pardon could be guilty of a crime if the whole field related to pardons is roped off from federal congressional influence and our ability to criminalize the act. Everybody seems to think it would be a bribe, but they can't explain why we can legislate there. But I want to give them an analogy related to the Commerce Clause. I was thinking about it since some members were discussing it. The Commerce Clause is also written in a completely unlimited, absolute, and apparently plenary way. So plenary means that it can be undertaken for any purpose at all, that there are no purposes for which it cannot be undertaken. Well, the Supreme Court has clearly rejected that with respect to Congress's power in Article 1, Section 8, Clause 3, to regulate commerce among the states, which sounds absolute and plenary. Well, when has it carved into that principle? When the Congress has acted in such a way as to commandeer the resources or the laws of state and local governments. Now, there's a counter principle within the Constitution of the police powers of the states, which our friend from Texas invoked before. You can't say that the 10th Amendment does it because, of course, 10th Amendment powers are residual powers. They're not an affirmative grant of power. It's the ones that are not given to Congress, but Congress got those powers under the Commerce Clause. But nonetheless, the Supreme Court said in the Prince case and several other cases relating to anti-commandeering doctrine that under our system of government, states cannot be turned into mere instruments of the federal government. Similarly, see James Madison, under our system of government, no official can be a judge in his or her own case. nobody can appoint himself judge, jury, and executioner, and nobody's ever tried it before. Now, we're not taking that judgment away from this president or any president. If anyone would be so wrong, so unethical, so immoral, so lawless as to attempt to do it, then there's nothing that can stop them from trying to do it. That's why what our amendment says is simply that we consider it void and of no effect, and it shall not deprive the courts of jurisdiction. That is, the Article 3 branch is not deprived of jurisdiction, and it does not operate to confer any legal immunity or impunity from investigation or prosecution in the Article 1 branch for prosecutors. So all we're saying is the president can say whatever he wants, but if he's trying to deal himself a pardon, that runs against the most basic premises of our Constitution. So I would invite everybody who thinks it's wrong to consider the possibility it's also unconstitutional. I yield back. Thank you, Ms. Scanlon.
The gentleman yields back. For what purpose does Mr. McClintock seek recognition?
To strike the last word.
Gentleman is recognized.
Mr. Chairman, we've heard a lot today that no person is above the law. No one disagrees with that. But I think an important corollary to that is that no Congress is above the Constitution. The constitutional power to pardon is crystal clear. It's been repeated, it bears repeating again. The President shall have the power to grant reprieves and pardons for offenses against the United States except in cases of impeachment. That's it. That is the alpha and omega of the constitutional grant of authority to the executive branch to grant reprieves and pardons. It gives no role to the Congress in exercising this power, and it places no restrictions upon it. And there's only one way to change this, and that is by constitutional amendment. We can all agree that this power has been abused by past presidents in various cases. What we are unlikely to agree on is specifically which cases has that power been abused. No one believes the president should be able to pardon himself, and I think it's fairly clear that a president cannot pardon himself, and President Trump tweeting that he can certainly doesn't make it so. Richard Nixon never asserted this power, and if he had, or if it was ever seriously asserted, I think it would be immediately struck down. So I think this is a rather silly discussion to have to begin with. A very important check on an unjust judicial decision is the power of the pardon, and it is a uniquely executive power. Certainly, the judicial branch cannot act as a check on itself, and the partisan invective that we've heard here today, I think, supports the view that it should not be left to the legislative branch. That's a legitimate discussion to have, but it's a legislative discussion to have over a constitutional amendment, because any modification or condition or restriction on that power alters the Constitution, and that can only be done by amendment. If the Democrats were serious, we'd be considering that right now. It's the only legitimate course that we could take under the Constitution, unless, of course, the Democrats on this committee truly believe that they are above the Constitution. Yield back.
Gentleman yields back. The question occurs on the amendment. All in favor of the amendment say aye. Aye. Opposed, no. The ayes have it. The amendment is adopted. Are there any further amendments to the amendment in the nature of a substitute?
Roll call.
The gentleman will withdraw that vote, even though the gentleman was late. I will grant him his recorded vote.
Mr. Nadler?
Aye.
Mr. Nadler votes aye. Ms. Lofgren?
Aye.
Ms. Lofgren votes aye. Ms. Jackson Lee?
Aye.
Ms. Jackson Lee votes aye. Mr. Cohen? Mr. Johnson of Georgia? Mr. Johnson of Georgia? Mr. Deutsch? Ms. Bass? Mr. Richmond? Mr. Jeffries? Mr. Cicilline? Mr. Cicilline votes aye. Mr. Swalwell?
Aye.
Mr. Swalwell votes aye. Mr. Liu?
Aye.
Mr. Liu votes aye. Mr. Raskin?
Aye.
Mr. Raskin votes aye. Ms. Jayapal?
Aye.
Ms. Jayapal votes aye. Ms. Demings? Mr. Correa?
Aye.
Mr. Correa votes aye. Ms. Scanlon?
Aye.
Ms. Scanlon votes aye. Ms. Garcia? Ms. Garcia votes aye. Mr. Neguse? Mr. Neguse votes aye. Ms. McBath? Ms. McBath votes aye. Mr. Stanton? Mr. Stanton votes aye. Ms. Dean?
Aye.
Ms. Steen votes aye. Ms. McCarcel-Powell? Ms. McCarcel-Powell votes aye. Ms. Escobar? Ms. Escobar votes aye. Mr. Jordan? Mr. Jordan votes no. Mr. Sensenbrenner? Mr. Shabbat? Mr. Shabbat votes no. Mr. Gomert? Mr. Gomert votes no. Mr. Collins? Mr. Buck? Ms. Roby? Mr. Gates? Mr. Gates votes no. Mr. Johnson of Louisiana? Mr. Johnson of Louisiana votes no. Mr. Biggs? Mr. Biggs votes no. Mr. McClintock? Mr. McClintock votes no. Ms. Lesko? Ms. Lesko votes no. Mr. Reschenthaler? Mr. Reschenthaler votes no. Mr. Klein? Mr. Klein votes no. Mr. Armstrong? Mr. Armstrong votes no. Mr. Stubie? Mr. Stubie votes no. Mr. Tiffany? Mr. Tiffany votes no.
Are there any other members who wish to vote who haven't voted?
Mr. Chairman, how am I recorded?
Mr. Johnson of Georgia, you are not recorded.
Johnson of Georgia votes aye.
Mr. Johnson of Georgia votes aye. Ms. Demings, you are not recorded. Ms. Demings votes aye.
Anyone else?
Yes, he did.
Wait a minute. We got all the votes? We got all the votes. Has anyone else wishes to vote who hasn't voted? Clerk will report.
Mr. Chairman, there are 19 ayes and 13 noes.
The amendment is adopted. Without objection, I place this letter from a number of good government organizations supporting both of today's bills in the record. For what purpose does Mr. Reschenthaler seek recognition?
Mr. Chairman, I have an amendment at the desk.
Gentlemen, the clerk will report the amendment.
Thank you, Mr. Chairman.
Mr. Chairman, I reserve a point of order.
The point of order is reserved.
Well, thank you, Mr. Chairman. Mr. Chairman, my amendment would insert congressional findings that would highlight how Presidents Clinton and Obama abused their pardon power. My Democrat colleagues are so blinded by their obsession to take down President Trump that they flatly ignore how past presidents have abused their pardon power. Let's start with President Clinton. President Clinton blatantly used his pardon power to benefit his friends and family. He pardoned his brother, Roger Clinton, for cocaine-related felonies. He pardoned his business partner and a key Whitewater scandal witness, Susan McDougal, who refused to answer questions before a grand jury about whether President Clinton lied, and he pardoned her. President Clinton also pardoned his CIA director and his HUD secretary. It doesn't stop there. President Clinton granted clemency to 16 members of the Puerto Rican group Armed Forces of National Liberation, who the FBI linked to 146 bombings. Let me repeat that. 146 bombings, and Bill Clinton gave them clemency. He also pardoned international fugitive Mark Rich, a prominent Democrat donor who was wanted for fraud, tax evasion, racketeering, and illegal dealings with Iran. But I'm sure it was totally coincidental that Mark Rich just happened to be a big Democrat donor. Total coincidence. So if you still think President Trump is the one abusing his power, well, let's just talk about President Obama. President Obama commuted the sentences of Oscar Rivera Lopez, who was a known terrorist, He also pardoned Chelsea Manning, who compromised our national security by leaking classified information. He didn't stop there. President Obama pardoned his former vice chairman of the Joint Chiefs of Staff, who was convicted of making false official statements to federal investigators. So, Mr. Chairman, the Democrats' failure to acknowledge controversial pardons of past presidents makes one thing clear: that this bill is nothing more than another petty attack on this administration and this president. Don't let the Democrats fool you. We're not here to further legitimate congressional oversight. We're here because Democrats cannot stop their relentless and unfounded attacks on a duly elected president. Thank you, Mr. Chairman, and I yield back the remainder of my time.
Does the gentlelady insist on a point of order?
At this time, I insist on my...
Gentlelady insists on a point of order. I will rule that the point of order is well taken. The motion is out of the amendment is out of order. Appeal the ruling of the
Mr.
chair.
Chairman, I would appeal.
The motion to table. Clerk will call the roll on the motion to table.
Mr. Nadler?
Aye.
Mr. Nadler votes aye. Ms. Lofgren?
Aye.
Ms. Lofgren votes aye. Ms. Jackson Lee? Ms. Jackson Lee votes aye. Mr. Cohen? Mr. Johnson of Georgia?
Aye.
Mr. Johnson of Georgia votes aye. Mr. Deutsch? Ms. Bass? Mr. Richmond? Mr. Richmond votes aye. Mr. Jeffries? Mr. Cicilline?
Aye.
Mr. Cicilline votes aye. Mr. Swalwell? Mr. Swalwell votes aye. Mr. Liu?
Aye.
Mr. Liu votes aye. Mr. Raskin?
Aye.
Mr. Raskin votes aye. Ms. Jayapal? Ms. Demings? Ms. Demings votes aye. Mr. Correa?
Aye.
Mr. Correa votes aye. Ms. Scanlon?
Aye.
Ms. Scanlon votes aye. Ms. Garcia? Ms. Garcia votes aye. Mr. Neguse? Mr. Neguse votes aye. Ms. McBath? Ms. McBath votes aye. Mr. Stanton? Mr. Stanton votes aye. Ms. Dean?
Aye.
Ms. Dean votes aye. Ms. McCarcel-Powell? Ms. McCarcel-Powell votes aye. Ms. Escobar? Ms. Escobar votes aye. Mr. Jordan? Mr. Jordan votes no. Mr. Sensenbrenner? Mr. Shabbat? Mr. Gomert? Mr. Gomert votes no. Mr. Collins? Mr. Buck? Ms. Roby? Mr. Gates? Mr. Gates votes no. Mr. Johnson of Louisiana? Mr. Johnson of Louisiana votes no. Mr. Biggs? Mr. Biggs votes no. Mr. McClintock? Ms. Lesko? Ms. Lesko votes no. Mr. Reschenthaler? Mr. Reschenthaler votes no. Mr. Klein? Mr. Klein votes no. Mr. Armstrong? Mr. Stubie? Mr. Stubie votes no. Mr. Tiffany? Mr. Tiffany votes no.
Clerk will report.
Mr. Chairman, could I get a
The
point
clerk
of
will
order?
report.
Mr. Chairman, can I get
The
a point
clerk
of
will
order?
report. The clerk will report.
Okay, okay.
Ms. Shabbat?
Yeah.
Mr. Shabbat votes no.
Mr. Chairman, can we just...
The clerk will report.
1911.
Mr. Chairman?
Mr. Chairman, there are 19 ayes and 11 noes.
And the amendment and the motion is laid on the table. Are there any
Mr.
other
Chairman,
amendments?
I just have
Are there
a
any
parliamentary
further
inquiry.
amendments? Are there any further amendments in the nature of a substitute?
Mr. Chairman, I got a parliamentary inquiry. I just want on the record you to state why you ruled the way you did.
That is not a proper parliamentary inquiry. With the,
Mr. Chairman, you have to have grounds.
I do, but I don't have to, but that matter is over. Are there any further amendments in the nature of a
Miss-
substitute?
Yes, Mr. Chair.
Who seeks recognition? Ms.
Congresswoman
Lesko.
Lesko, yes. Mr. Chair, I have an amendment at the desk.
The clerk will report the amendment.
David.
Amendment to the amendment
And the
in the
gentlelady
nature of a
reserves a point of
substitute
order.
to
Is there a
HR
point of order?
7694 offered by Ms. Lesko.
Thank you, Mr. Chair. My amendment adds congressional findings. The Congress finds as follows. On January 25, 2001, the New York Times editorial board condemned several pardons granted by President Clinton as pardons on the
Mr. Chairman, I reserve a point of order.
designed to
Point of order
reward
is
friends,
reserved. The gentlelady will continue.
reward friends or political allies or gain future political advantage. Among those pardons that the Times condemned was that of Susan Rosenberg, a member of the Weather Underground, an organization described by the Federal Bureau of Investigation as a domestic terrorist group that claimed credit for 25 bombings, including the U.S. Capitol, the Pentagon, the California Attorney General's office, and a New York City police station. After President Clinton pardoned his brother, his business partner, who was in jail for refusing to testify about President Clinton, a political donor, and 17 individuals who are members of terrorist organizations. On February 28, 2001, you, Mr. Nadler, then the ranking member on the Subcommittee on the Constitution, argued in a hearing regarding the presidential pardon power that, quote, there is little disagreement among legal scholars that this power is unrestricted as applied to offenses against the United States, excluding impeachment. There seems to be little disagreement among scholars that Congress has no power whatsoever to put any restrictions or conditions or guidelines on the exercise of this power other than by starting a constitutional amendment. Then on September 16, 1999, then Attorney General Janet Reno argued in a memorandum to President Clinton that President Clinton should assert executive privilege to preclude the disclosure of documents relating to this granting of clemency to 16 members of the Puerto Rican group, the Armed Force of National Liberation, that the FBI linked to over 146 bombings. Attorney General Reno further argued that Congress lacks any authority whatsoever to review a president's clemency decision, and that Congress's oversight authority does not extend to the process employed in connection with a particular clemency decision, to the materials generated or the discussions that took place as part of that process, or to the advice or views the president received in connection with a clemency decision. In addition, the Supreme Court has noted on several occasions that the pardon power is within the exclusive authority of the executive branch. In Ex parte Garland, the court stated, quote, this power of the president is not subject to legislative control. In United States versus Klein, the court stated, quote, to the executive alone is entrusted the power of pardon. And Justice Kennedy in Public Citizen versus Department of Justice stated that the pardon power is committed to the exclusive control of the president. Mr. Chairman, despite Democrats previously arguing that Congress has, quote, no power whatsoever to address presidential pardons when President Clinton was in power, Democrats now wish to insert themselves in a process that the Constitution solely vests in the president, and I think it's fair to include that in your amendment. And with that, I yield back.
The gentlelady yields back. I recognize myself in opposition to the amendment. The amendment is...
Withdraw my objection.
Gentlelady's objection. I recognize myself in opposition to the amendment. The amendment has nothing to do whatsoever with the bill at all, and we shouldn't waste our time debating an amendment that has nothing to do with the bill. I yield back. Who seeks recognition? The question occurs on the amendment. All in favor of the amendment say aye. Aye. Opposed? I mean, no? No. No. The noes have it.
Roll call vote, please.
Roll call is requested. The clerk will call the roll.
Mr. Nadler?
No.
Mr. Nadler votes no. Ms. Lofgren?
No.
Ms. Lofgren votes no. Ms. Jackson Lee? No. Ms. Jackson Lee votes no. Mr. Cohen? Mr. Johnson of Georgia? Mr. Deutsch? Ms. Bass? Mr. Richmond? Mr. Richmond votes no. Mr. Jeffries? Mr. Cicilline?
No.
Mr. Cicilline votes no. Mr. Swalwell? No. Mr. Swalwell votes no. Mr. Liu?
No.
Mr. Liu votes no. Mr. Raskin?
No.
Mr. Raskin votes no. Ms. Jayapal?
No.
Ms. Jayapal votes no. Ms. Demings? No. Ms. Demings votes no. Mr. Correa? No. Mr. Correa votes no. Ms. Scanlon?
No.
Ms. Scanlon votes no. Ms. Garcia? Ms. Garcia votes no. Mr. Neguse? Mr. Neguse votes no. Ms. McBath? Ms. McBath votes no. Mr. Stanton? Mr. Stanton votes no. Ms. Steen?
No.
Zoom call.
Ms. Steen votes no. Ms. Mucarsel-Powell?
Committee meeting, and I just, they'll have to come back to me on that. vote.
Ms. Mucarsel-Powell
But,
votes
so
no. Ms. Escobar? Ms. Escobar votes no. Mr. Jordan? Mr. Sensenbrenner? Mr. Shabbat?
You're probably going to do a few more.
Mr. Gomert? Mr. Gomert votes yes. Mr. Collins? Mr. Buck? Ms. Roby? Mr. Gates? Mr. Gates votes aye. Mr. Johnson of Louisiana? Mr. Johnson of Louisiana votes aye. Mr. Biggs? Mr. Biggs votes aye. Mr. McClintock? Ms. Lesko? Ms. Lesko votes aye. Mr. Reschenthaler? Mr. Reschenthaler votes aye. Mr. Klein? Mr. Klein votes aye. Mr. Armstrong? Mr. Stubie? Mr. Stubie votes yes. Mr. Tiffany? Mr. Tiffany votes aye.
Mr. Chairman,
Mr. Johnson of Georgia?
how am I recorded?
You are not recorded.
I vote no.
Mr. Johnson of Georgia votes no. Mr. Shabbat votes aye.
Are there any other members who haven't voted who wish to vote? The clerk will report.
Mr. Chairman, there are 10 ayes and 20 noes.
The amendment is not agreed to. Are there any further amendments to the amendment in the nature of a substitute?
Mr. Chairman,
Mr. Biggs, for what purpose does Mr. Biggs seek recognition?
I have an amendment at the desk.
Clerk will report the amendment.
Chairman, I reserve a point of order.
Amendment to the amendment in the nature of a substitute to H.R. 7694, offered by Mr. Biggs. Page 1, insert after line 3 the following.
Gentleman is recognized. The point of order is reserved.
Thank you, Mr. Chairman. I realize that you felt that the last amendment was a waste of time. I get that, and you're going to probably say the same thing about this. I'm very comfortable with that. Much like I feel this bill and the previous bill are also a waste of time. But you know what? Sometimes the American public looks at what we're doing, and they think what we're doing is a waste of time. But even the fact that we're debating, and I thought we had some actual substantive debate a little bit on earlier today, that's remarkable. Doesn't happen all the time here, but I was grateful for that. But my amendment here doesn't change the operation of the underlying bill, but it does add what I think is something that's really necessary here, and that's context. It's context to what y'all who've introduced this bill are trying to do. The fact is, I hear from my constituents repeatedly that there are really two criminal justice systems at work in this country, and I think some of you hear that too. One that is used to excuse the misconduct of Democrats and their allies, and one that's used to aggressively go after individuals who are associated with President Trump. The Inspector General for the Department of Justice, appointed by President Obama, concluded that, for instance, that former FBI Deputy Director Andrew McCabe lied to federal investigators. The Inspector General referred McCabe for criminal prosecution, and nothing happened. And I hold, our current Attorney General drives me crazy. Why didn't anything happen there to prosecute Mr. McCabe for his lying? But what's really intriguing is that there was no pre-dawn raid, like in the Roger Stone case. There was no CNN cameras until Mr. McCabe signed a contract to go on CNN as a commentator. There was no accountability. The Inspector General for the Department of Justice concluded that former FBI Director James Comey mishandled classified information by leaking memoranda in an attempt to spur a special counsel investigation. The Inspector General concluded that Comey's misconduct was designed to achieve a personally desired outcome. That should put a chill on everybody, regardless of your party, that someone who has control of the police apparatus is leaking information to create a special counsel investigation for what? A personally desired outcome. The Inspector General accordingly referred him for criminal prosecution, but nothing happened. No pre-dawn raid, no CNN cameras, no accountability, just a book tour. In our country, nobody's supposed to be above the law. I have heard that multiple times today. And so I think the reason I've introduced this amendment is for context. It's long past time that our criminal justice system treats everybody alike. Everybody, irrespective of their political affiliation, and that the law pursues misconduct to the fullest extent of the law. I would encourage adoption of this amendment. I think the context is important for the history of this country should your bill become law. Thank you, Mr. Chairman, and with that, I'll yield.
I'll yield myself time in opposition to the amendment. We have this amendment includes findings of fact, most of which are not true. They go to the bill, which has very little to do with it. The bill deals with procedures for pardons. These findings of fact do not. In any event, we have debated these findings of fact 10 or 20 times today so far. I would urge that we shouldn't waste our time debating them again, but in any event, I oppose the amendment for all these reasons. I yield back. Who else seeks recognition? I recognize Mr. Tiffany.
I move to strike the last word.
Gentleman is recognized.
I speak in favor of the amendment that is put forth by the representative from Arizona. He is absolutely correct. And I want to share the Wisconsin example that you should all know is chilling and why there should be consequences. We had something called the John Doe process in Wisconsin, and we had the John Doe cases in Wisconsin where a prosecutor and a state government employee teamed up to go after people for political speech. They did not like it when Scott Walker won the governorship, and then he transformed Wisconsin into a much better state. And some of them could not take that, so they went after those people who were simply participating in politics. Pre-dawn raids, there were multiple pre-dawn raids, I believe it was in October of 2013, sent SWAT teams, armed to the hilt, SWAT teams, to people's doors and accosted them. One family, they had left for the day, husband and wife. The only person home was their 16-year-old son. Their 16-year-old son was greeted with that knock at the door, and he asked, after they took all of their effects, computers, files, all those things, and they said, "You're charged under the John Doe laws of the state of Wisconsin." The young man, 16 years old, said, "Can I call my grandparents?" No. Under the John Doe law of Wisconsin, you are sworn to secrecy. You can't tell anybody. "Can I call my principal? Tell him I'm going to be late to school." No, you can't call anybody. So I rewrote the John Doe laws here in Wisconsin so it could never be used for political persecution again. However, those people that foisted that on the people of the state of Wisconsin, they were never prosecuted. It's the one regret that I will always have is that those people that went into people's homes with armed SWAT teams with dubious charges that turned out to be untrue, that they were never held. They were never held to the law. And it goes to the point that Representative Biggs is saying, let's have equal justice under the law. So I stand fully in favor of this amendment to make sure that everyone in America knows that there will be justice, especially when it comes to protecting the First Amendment of free political speech. I yield back.
Gentleman yields back. Mr. Reschenthaler?
Mr. Chairman, I move to strike the last word.
Gentleman is recognized.
Thank you, Mr. Chairman. I support the amendment offered by my good friend from Arizona. And I think it's important that the American people have the whole picture before we vote on this bill today. You know, we've talked a lot today about the Federalist Papers, the Founding Fathers, and about their support for the bill. But we don't have to go back to the founding. We just have to go back to the early 2000s. Go back to the early 2000s when Democrats talked about these issues in their own words. In particular, Mr. Chairman, I'd like to highlight your own comments at a Judiciary Committee hearing back in 2001. Mr. Chairman, you said the following regarding presidential pardon power, and I quote, "There is little disagreement among legal scholars that this power is unrestricted as applied to offenses against the United States, excluding impeachment. There seems to be little disagreement among scholars that Congress has no power whatsoever to put on restrictions or conditions or guidelines on the exercise of this power, other than by starting a constitutional amendment." Mr. Chairman, those were your own words. And just a few minutes ago, I think what you were struggling with was relevancy. Well, there's no question that your own words are germane. There's no questions that your own words are relevant. And when you said in 2001 that there's little disagreement among legal scholars about this, that there seems to be little disagreement among scholars that Congress does not have this power, how can you now argue just a few years later that there is the need for this in the constitutional authority? So, Mr. Chairman, let me just sum this up for you. As you said in Congress just a few years ago, there's no power whatsoever to put restrictions or conditions on the president's pardon power. You're here today saying the exact opposite. And why is that? Well, it's simple. Because Democrats are simply grasping at straws. You're wasting precious time and effort when we could be doing real work like criminal justice reform, like protecting and strengthening America's intellectual property laws. There's so much that we could be doing that would be constructive for the American people, but instead we're squandering the opportunity, contradicting ourselves or yourselves from just years ago. So, Mr. Chairman, I would just ask that moving forward, there's intellectual honesty, that there's coherent argument, and that you put down this witch hunt, that you put down your persecution of this administration and do something that's productive. Thank you. I yield back the remainder of my time.
The gentleman yields back. The question occurs on the amendment. All in favor say aye. Aye. No, no. The amendment is denied. The amendment is not approved. Are there any roll call is requested? The clerk will call the roll.
Mr. Nadler?
No.
Mr. Nadler votes no. Ms. Lofgren?
No.
Ms. Lofgren votes no. Ms. Jackson-Lee? Mr. Cohen? Mr. Johnson of Georgia?
And votes aye.
Mr.
No, I vote no. I vote
Mr. Cohen votes no. Mr. Johnson of Georgia? Mr. Johnson of Georgia?
No.
Mr. Johnson of Georgia votes no. Mr. Deutsch? Ms. Bass? Mr. Richmond? No. Mr. Richmond votes no. Mr. Jeffries? Mr. Cicilline? Mr. Swalwell? Mr. Swalwell votes no. Mr. Liu?
No.
Mr. Liu votes no. Mr. Raskin?
No.
Mr. Raskin votes no. Ms. Jayapal?
No.
Ms. Jayapal votes no. Ms. Demings? No. Ms. Demings votes no. Mr. Correa?
No.
Mr. Correa votes no. Ms. Scanlon?
No.
Ms. Scanlon votes no. Ms. Garcia? No. Ms. Garcia votes no. Mr. Neguse? No. Mr. Neguse votes no. Ms. McBath? No. Ms. McBath votes no. Mr. Stanton? No. Mr. Stanton votes no. Ms. Dean? Ms. Dean votes no. Ms. McCarcel-Powell? Ms. McCarcel-Powell votes no. Ms. Escobar? Ms. Escobar votes no. Mr. Jordan? Mr. Jordan votes yes. Mr. Sensenbrenner? Mr. Shabbat? Mr. Shabbat votes aye. Mr. Gomert? Mr. Gomert votes aye. Mr. Collins? Mr. Buck? Ms. Roby? Mr. Gates? Mr. Gates votes aye. Mr. Johnson of Louisiana? Mr. Johnson of Louisiana votes aye. Mr. Biggs? Mr. Biggs votes aye. Mr. McClintock? Ms. Lesko? Ms. Lesko votes aye. Mr. Reschenthaler? Mr. Reschenthaler votes aye. Mr. Klein? Mr. Armstrong? Mr. Stubie? Mr. Stubie votes yes. Mr. Tiffany?
Aye.
Mr. Tiffany votes aye.
Are there any members who haven't voted who wish to vote? Clerk will report.
Mr. Chairman, there are 10 ayes and 19 noes.
The amendment is not agreed to. The committee will stand in recess for 5 minutes. Committee will reconvene. Are there any other amendments to the amendment in the nature of a substitute?
Yeah, thank you, Mr. Chair. I have an amendment.
What purpose does Ms. Lesko seek recognition?
Thank you, Mr. Chair. I have an amendment at the desk.
Clerk will report the amendment.
Amendment to the amendment in the nature of a substitute to H.R. 7694, offered by Ms. Lesko. Page 1, insert after line 3 the following.
The amendment will be considered as read. The gentlelady is recognized.
Thank you, Mr. Chairman. This amendment is on congressional findings. This amendment highlights how President Trump has used his pardon power to grant clemency to individuals who I believe, and he believed, had unjust sentences or prosecutions. The Congress finds as follows: since taking office, President Trump has granted 36 pardons and commutations. President Trump has used his pardon power to grant clemency to individuals who received an unjust sentence or prosecution. On May 24, 2018, President Trump posthumously pardoned African-American boxer John Arthur Jack Johnson, who was convicted in 1913 on 7 counts of violating the White Slave Traffic Act, Mann Act, by an all-white jury. Civil rights groups and advocates petitioned past presidents to officially recognize that Johnson's prosecution and conviction embodied racial hostility and intolerance. When pardoning Johnson, President Trump stated, Johnson had a conviction that occurred during a period of tremendous racial tension in the United States more than a century ago. Johnson served 10 months in federal prison for what many view as a racially motivated injustice. He was treated very rough, very tough. On June 6, 2018, President Trump commuted the life sentence of Alice Johnson, a first-time offender who had already served 22 years for drug-related offenses. In a press release, the White House noted that Alice Johnson had accepted responsibility for her past behavior and been a model prisoner. The release stated that while this administration will always be very tough on crime, it believes that those who have paid their debt to society and worked hard to better themselves while in prison deserve a second chance. On February 18, 2020, President Trump commuted the sentences of 3 mothers based upon the recommendation of their recently freed fellow inmate Alice Johnson as follows. At the time of her commutation, Tyneese Hall had already served 14 years of her 18-year sentence for a drug-related conviction. Similarly, Crystal Munoz had been imprisoned for 12 years for her small role in a marijuana smuggling ring. Judith Negron received a 35-year prison sentence for her role in a healthcare fraud scheme and had already served 8 years. The White House stated the 3 women had paid their debts to society and worked to improve their lives and the lives of others while incarcerated. And so I wanted to offer this amendment because so often we talk, or at least my Democratic colleagues talk about negative things they believe about President Trump, but I think these are positive things and should be included. And they were things he pardoned these people on that other presidents, previous presidents, were asked to pardon and they did not, and he did. And with that, I yield back.
Gentlelady yields back. I recognize myself in opposition to the amendment. The amendment is a statement of facts regarding certain pardons, as the last few amendments were. It is wrong to pick out a few pardons. It has nothing to do with the merits of the bill. The bill deals with these simply talk about facts of a few pardons among the many that presidents have issued over the years. It is wrong to single out a few pardons, to talk about it one way or the other. We've discussed these anyway today several times, and therefore I oppose the amendment. Who else seeks recognition on this amendment? Seeking none, the question occurs on the amendment. All in favor say aye. No, no, no. The noes have it. The roll call is requested. The clerk will call the roll.
Mr. Nadler?
No.
Mr. Nadler votes no. Ms. Lofgren?
No.
Ms. Lofgren votes no. Ms. Jackson-Lee? Mr. Cohen?
No.
Mr. Cohen votes no. Mr. Johnson of Georgia?
No.
Mr. Johnson of Georgia votes no. Mr. Deutsch? Ms. Bass? Mr. Richmond? No. Mr. Richmond votes no. Mr. Jeffries? Mr. Cicilline?
No.
Mr. Cicilline votes no. Mr. Swalwell? Mr. Liu?
No.
Mr. Liu votes no. Mr. Raskin?
Nope.
Mr. Raskin votes no. Ms. Jayapal?
No.
Ms. Jayapal votes no. Ms. Demings? No. Ms. Demings votes no. Mr. Correa? Ms. Scanlon?
No.
Ms. Scanlon votes no. Ms. Garcia? No. Ms. Garcia votes no. Mr. Neguse? No. Mr. Neguse votes no. Ms. McBath? No. Ms. McBath votes no. Mr. Stanton? No. Mr. Stanton votes no. Ms. Dean? No. Ms. Dean votes no. Ms. McCarcel-Powell? No. Ms. McCarcel-Powell votes no. Ms. Escobar? No. Ms. Escobar votes no. Mr. Jordan? Yes. Mr. Jordan votes yes. Mr. Sensenbrenner? Mr. Shabbat? Mr. Shabbat votes aye. Mr. Gomert? Mr. Collins? Mr. Collins votes aye. Mr. Buck? Ms. Roby? Mr. Gates? Mr. Johnson of Louisiana? Mr. Biggs? Mr. Biggs votes yes. Mr. McClintock? Mr. McClintock votes aye. Ms. Lesko? Ms. Lesko votes aye. Mr. Reschenthaler? Mr. Reschenthaler votes aye. Mr. Klein? Mr. Klein votes aye. Mr. Armstrong? Mr. Stubie? Mr. Stubie votes yes. Mr. Tiffany? Mr. Tiffany votes aye. Mr. Correa votes no. Mr. Swalwell, you're not recorded. Mr. Swalwell votes no.
Are there any members who wish to vote who haven't voted? The clerk will report.
Mr. Chairman, there are 10 ayes and 20 noes.
The amendment is not agreed to. Are there any other amendments to the amendment in the nature of a substitute? We will proceed to a vote on the amendment in the nature of a substitute. Question occurs on the amendment in the nature of a substitute. This will be followed immediately by a vote on final passage of the bill. All those in favor respond by saying aye. Opposed, no. The ayes have it. In the opinion of the chair, the ayes have it, and the amendment in the nature of a substitute is agreed to. We will now proceed. A reporting quorum being present, the question is on the motion to report the bill H.R. 7694 as amended favorably to the House. Those in favor respond by saying aye. Opposed, no. The ayes have it. Roll call is requested. The clerk will call the roll.
Mr. Nadler?
Aye.
Mr. Nadler votes aye. Ms. Lofgren?
Aye.
Ms. Lofgren votes aye. Ms. Jackson-Lee? Ms. Jackson-Lee votes aye. Mr. Cohen?
Cohen votes aye.
Mr. Cohen votes aye. Mr. Johnson of Georgia?
Aye.
Mr. Johnson of Georgia votes aye. Mr. Deutsch? Ms. Bass? Mr. Richmond? Mr. Jeffries? Mr. Cicilline?
Aye.
Mr. Cicilline votes aye. Mr. Swalwell?
Aye.
Mr. Swalwell votes aye. Mr. Liu?
Aye.
Mr. Liu votes aye. Mr. Raskin?
Aye.
Mr. Raskin votes aye. Ms. Jayapal?
Aye.
Ms. Jayapal votes aye. Ms. Demings? Ms. Demings votes aye. Mr. Correa?
Aye.
Mr. Correa votes aye. Ms. Scanlon?
Aye.
Ms. Scanlon votes aye. Ms. Garcia? Ms. Garcia votes aye. Mr. Neguse? Mr. Neguse votes aye. Ms. McBath? Ms. McBath votes aye. Mr. Stanton? Mr. Stanton votes aye. Ms. Dean? Ms. Dean votes aye. Ms. McCarcel-Powell? Ms. McCarcel-Powell votes aye. Ms. Escobar? Ms. Escobar votes aye. Mr. Jordan? Mr. Jordan votes no. Mr. Sensenbrenner? Mr. Shabbat? Mr. Shabbat votes no. Mr. Gomer? Mr. Collins? Mr. Collins votes no. Mr. Buck? Ms. Roby? Mr. Gates? Mr. Johnson of Louisiana? Mr. Johnson of Louisiana votes no. Mr. Biggs? Mr. Biggs votes no. Mr. McClintock? Mr. McClintock votes no. Ms. Lesko? Ms. Lesko votes no. Mr. Reschenthaler? Mr. Reschenthaler votes no. Mr. Klein? Mr. Klein votes no. Mr. Armstrong? Mr. Stubie? Mr. Stubie votes no. Mr. Tiffany? Mr. Tiffany votes no.
Has every member who wished to vote voted?
Mr. Richmond, you are not recorded. Mr. Richmond votes yes.
Mr. Jeffries?
Mr. Jeffries votes aye.
Are there any other members who wish to be recorded who haven't been recorded? Who's that back there?
Are there any other members?
The clerk will report.
Mr. Chairman, there are 22 ayes and 11 noes.
The ayes have it. The bill as amended is reported favorably to the House. Members will have 2 days to submit views. Without objection, the bill will be reported as a single amendment in the nature of a substitute incorporating all adopted amendments, and staff is authorized to make technical and conforming changes. This concludes our business for today. Thanks to all of our members for attending. Without objection, the markup is adjourned.